All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 7th, 2024. We have 11 bills on the docket, and we're going to start off with Senate Bill 889. We'll then move to 899, 898, 962, 1108, 1031, 901, 635, 946, 992, and we'll wrap up with Senator Folden with Senate Bill 885. So without further delay, we'll start off with Senate Bill 889. Welcome.
Good afternoon, Mr. Chair, members of the committee. My name is Joshua Auerbach from the Office of the Attorney General. I spent a substantial part of my time in the Attorney General's office working on civil regulatory enforcement. And by that, I mean enforcement of laws where the Attorney General is not acting on behalf of a client, but the Attorney General, in fact, has the primary enforcement role. And I want to try and make 5 points in the time I have. First, SB 889 is a bill that would clarify the law, not change the law. The 1-year limitation in Section 5107, of course, in judicial proceedings, dates all the way back, believe it or not, to 1777. It's a limitation on prosecutions for fines. I haven't done research about what fines were in existence at that time. The idea of the illegal slaughterhouse in the middle of town, something like that. We live in a very different world, and this statute was never intended to apply to civil enforcement of statutes like the Consumer Protection Act, the Securities Act, the Antitrust Act, or the Civil Rights Law that was enacted last year. Consumer fraud was a concept that didn't exist in 1777. How do we know that it wasn't intended to apply? Because if your 20th century predecessors in enacting the Consumer Protection Act, for example, in the Commercial Law article, or the Securities Act in the Corporations and Associations article, had meant for those statutes to be subject to this 18th century limitation in an entirely other part of the code, they would have said so. The statutes we're talking about are comprehensive in nature. They've detailed instructions about civil enforcement in general and penalties in particular. None of them mentions Section 5107 or even hints that Section 5107 is applicable. Second point, the Maryland appellate courts have already repeatedly recognized that Section 5107 doesn't apply in actions brought in administrative proceedings, including in a decision issued just this fall by the Appellate Court of Maryland in the Cricket case. This is an important point I think it's worth emphasizing. As a result of a series of decisions going back several decades, it's already clear that Section 5107 does not apply when OAG initiates enforcement through its own administrative processes. The law is not quite as clear, however, when the Attorney General brings an enforcement action in court rather than administrative proceedings. This is because of a decision issued 35 years ago by a federal court in a case called Attorney General versus Dixon, which involved an odometer rollback scheme. And I may say a little bit more about that in a minute. The purpose of SB 889 is to make sure that what applies in administrative proceedings also applies in court. Third point, when I found out that Section 5107 dates all the way back to the 18th century, it didn't surprise me because, to put it bluntly, a 1-year limitation on penalties and civil regulatory enforcement just makes no sense. And here I want to rely a little bit on my own experience in cases brought under the Consumer Protection Act. It happens all the time that we don't even learn about really egregious violations of the law until more than 1 year after the conduct occurs. In those cases, if Section 5107 applied, we would have lost the ability to seek or impose penalties before we even got started investigating the case. There are other cases where it takes more than a year, this is quite common, to investigate complicated alleged wrongdoing. There, we would lose the ability to impose penalties by the fact of investigating. And then there are cases, and these are rather common too, where defendants, targets of investigation, don't cooperate, don't fully cooperate. We have to go to court to enforce a subpoena, and it can take months, in some cases even years, to get a court order enforcing a subpoena just to move forward with our investigation. All of that, if this 1 year limitation applied, which we've consistently said it doesn't, would sweep away the ability to impose penalties and really make penalties meaningless in the most important cases and the most difficult cases that we bring. Fourth point, maybe this one goes without saying, penalties are important. We know that penalties serve a critical deterrent purpose in law enforcement. You, the legislature, gave the Attorney General authority to seek or impose penalties in all of these statutes in the Consumer Protection Act, the Securities Act, the Civil Rights Law from last year. You didn't give that authority with the intention that it be meaningless in the hardest cases, in the most complicated cases. Last point. One particularly bad consequence of the lack of clarity around Section 5107 in court is that it gives an incentive for people who are the subjects of investigations to refuse to cooperate with investigations or to drag their feet. If you delay things long enough under this incorrect argument, penalties are off the table. It seems exceedingly unlikely that your predecessors, when they enacted the Consumer Protection Act, Securities Act, et cetera, intended Section 5107 to apply to a statutory enforcement by the Office of the Attorney General. SB 889 would be very helpful in making clear once and for all that it doesn't apply and that penalties are meaningful and effective in civil regulatory enforcement. Thank you.
Excellent. Thank you very much. Questions from the committee. Senator West.
Thank you, Mr. Chair. So thanks for bringing this bill, I guess. So last year we had House Bill 1, which eliminated statute of limitations for actions brought about alleged sexual mistreatment for minors. And I predicted at the time that if we passed this bill, eliminating the statute of limitations in those cases, that we were going to end up with a plethora of additional bills, also asking for the elimination of the statute of limitations. So here we are a year later, and this bill comes before us. Do you not agree with the general adage that justice delayed is justice denied?
I think it's a mistake to compare. First of all, I don't think this is not something that's following on the heels of in any respect. This is something that we've been working on for decades. And I was litigating a case. This
first time it's been before us.
So just to be clear, and I think it's a mistake to analogize civil regulatory enforcement to private law contexts.
Well, we have another bill before us this afternoon to eliminate statute of limitations in another class of cases. So what we're seeing now is the progeny, I think, of what we did last year, eliminating the statute and statute of limitations in House Bill 1. But wouldn't you agree with me that the more time that passes between the event that gives rise to a lawsuit and the actual litigation in court, the more likely it is that witnesses' memories are going to fade, that witnesses are going to move away and be unavailable, that witnesses are going to die, that critical documents which could influence the outcome of the case are going to be innocently discarded. And the longer you wait, the more unlikely it is that you're going to get a just result in court.
Yes, I agree with that. I think, on the other hand, it's very hard to prove a case under those circumstances too, particularly for a government enforcement agency. And in the case of government enforcement, there are all kinds of pressures on the other side. Again, not knowing about the conduct, taking time to investigate the conduct. We're in a different position than a private litigant who's been harmed by some tort. We're out to protect the public. We learn about conduct that's alleged to be wrongful, sometimes very complex, sometimes requires depositions, review of hundreds of thousands or millions of pages of documents. And so, of course, I agree with the general proposition that statute of limitations serve an important purpose.
Let's talk about the time it takes to get ready for a case. I'm very sympathetic to your argument that the 1 year statute in Section 5107 is just too restrictive. But your bill eliminates it entirely, correct? If your bill's passed, there's no statute of limitations whatsoever in these cases.
I think it's important to be clear. Our bill clarifies. I mean, this is the law as it has been recognized to be for decades in administrative enforcement, and the position of the office has been that it doesn't apply. And I guess the other thing I'd say is it would put us in a position analogous to that of most of the other states with which we work, at least in the consumer protection context. I know the best.
Well, we did have different length statute limitations for different types of situations. The general statute in Maryland is 3 years, longer than the 1 year in this statute. For fraud cases, as I recall, it's 10 years. For specialties and contract cases, it's 12 years. Instead of asking for a complete elimination of the statute of limitations, did you give any consideration to requesting that it be extended to 3 years, 10 years, or 12 years?
Well, as I said, the long-standing position of the office has been that this just doesn't apply. I mean, that it was not intended to apply to civil regulatory.
Have the courts
enforcement.
accepted that interpretation?
The courts have consistently accepted that interpretation with respect to administrative proceedings. And as I've said, there's this 35-year-old decision for judicial actions from federal court. No Maryland appellate court has ever said, no Maryland court has ever said that it does, Maryland appellate court has ever said that it does apply.
But this bill goes beyond administrative proceedings, doesn't it?
It does. It's intended to clarify the judicial context.
Okay.
And, but you're, of course, you're correct that there are limitations, other limitations in law, including the 12-year limitation on specialties that you mentioned, where lenders can sue borrowers 12 years later.
If the contract is under seal.
If it's a seal or it's otherwise a specialty. That's
Exactly.
right.
So I look at the second half of your bill, which is written to the commercial law article, section 11-209, which currently has a 4-year statute of limitations. What is that all about? You haven't discussed that in your testimony.
We were proposing to omit that from the bill and just address the section 5107.
Okay,
issue.
so you will not be unhappy if we just take the second part of your bill out.
Yeah, I think in fact, I'm a little bit out of sync with what we're doing, but my understanding is we propose that it be taken out.
Okay, well, that would help. And then the last question is, there's nothing in here about when this, what cases this would apply to. Are you willing to accept a provision that says this bill would apply prospectively instead of retroactively?
I think I'd want to think about that. I think we'd want to think about that because, as I said, our position has been all along, look, if there was limitations on the Consumer Protection Act penalties, the legislature would have said so in the Consumer Protection Act. So that would be a change for us.
Yeah, there is a constitutional issue involved in applying a statute of limitation retroactively to cover offenses for which the statute has long since run. And that's being currently challenged in court with respect to House Bill 1. You don't want to get yourself into another challenge like that with this case, do you?
My understanding is that it's much more complicated than that.
Well, it is
that
more.
the Maryland
It
courts
is
have
more
not accepted that there are vested rights in the expiration of statute of limitations. But I don't. Again, that is a very complicated issue.
House Bill 1 also involves the statute of repose, which is not involved here. Great. Well, thank you for your answers to my question.
Thank you very much.
Thank you, and thank you for going through your 5 points, which, by the way, I'm so unfamiliar with this that and I also don't want to make the hearing too long. You can follow up with me. I guess what I'd like to have is a better explanation of why what's the difference between an administrative, I'm a lawyer, administrative proceeding and one in court, just in terms of why the courts have consistently said there's no statute for administrative proceeding.
Yeah, well, so
what's that rationale?
An administrative proceeding, as you may know, is one typically initiated at the Office of Administrative Hearings, and then it goes for final decision to the division itself, and then it's subject to. Okay.
I'm just trying to figure out why. Apparently, I don't have a court case cited here. The courts have held on multiple occasions that 5-107 does not apply to administrative proceedings.
Two of the 3 decisions are in my testimony. The cricket case from this fall, the U.S. securities case. I can give you the
I don't
sites.
think I have your testimony now. I don't know when you.
I'm sorry to hear that last night. So let me give you 2 of them, if I may. Matter of cricket wireless, that's my case. 259 Maryland App 44. And then prior to that, Maryland Securities Commissioner.
Slow down. 259 Maryland App what?
44, year 2023. And then Maryland Securities Commissioner versus U.S. Securities Corporation, 122 Maryland App 574 from 1998. There's a third case that goes even further back. I mean, this has been a law for 50 years called Nelson versus Real Estate Commission. I'm afraid to say I don't have the site for that, but these 2 cases that I've just mentioned talk about Nelson as well. So we'll see the rationale. It's quite developed rationale. And look, this is the Courts and Judicial Proceedings article. It's not the Administrative Procedure Act. It's an entirely different part of the code. And so there's lots in there, but that's the essence of it.
Thank you for that. I guess what I have to read those cases to see whether the logic that applies, the guiding principle that applies to why it hasn't been interpreted in administrative proceedings is just as compelling in, article, whatever.
I mean, just to be totally candid about it, I mean, it turns in significant part on the distinction between administrative proceedings and court.
That's what I think too. So that's why I'm asking about it.
Yeah, no, it's a fair enough.
Question,
Yeah,
right?
yeah,
Because,
yeah.
And then I guess, all right, so the fiscal note goes on, and I guess were all administrative cases that protects the Consumer Protection Division, the Securities Division, and the Civil Rights Division. Now, is it your understanding that those various divisions can bring court cases without regard to a statute of limitations in article, I don't know what article is in our Constitution, our court system?
The position that we've taken is that 5107 doesn't apply, and at least for the Consumer Protection Act, there isn't a time limit that applies. Now, but to be
court.
in court, we've taken that position in court and in administrative proceedings. And we've said that this is part of the deep common law tradition. There's this fancy Latin phrase called nullum tempus. And the presumption in civil law is that limitations don't run against the state. And that's the position we've taken, along with the fact that it's from 1777, it's for something totally different.
I'm just trying to get information.
No, I understand.
All right. So then I guess, and are you saying there are court cases that have held these various divisions as having no statute of limitation in court? Is that correct?
No, I mean, there really
isn't
isn't a Maryland appellate decision on the court side.
Okay.
It's on the administrative side.
All right. So
The only published decision on this issue is this federal court decision that we think is incorrect.
I'm sorry, was that Cricket or Dixon? I was trying to write.
Dixon is the federal court decision from
Okay.
35 years
So
ago.
I'll have to.
Yeah. And I can give you that site too, if you like.
And then just to reiterate a little bit of what my colleague Senator West was saying, I'm not sure that we go from 1 year to no year. So I guess I'm gonna have to think, we should think about why it should be limitless for the very prejudicial reasons that can arise with the passage of time. And so far, I haven't heard you in your testimony give a compelling reason why it should be limitless as opposed to some date. So again, you all can follow up as to why it should be limitless and why that is still a fair position for us to be taking.
I think our main suggestion would be that if the legislature thinks that the Consumer Protection Act enforcement action ought to be time limited, it ought to amend the Consumer Protection Act.
Well, I'm not sure we have to. It depends, right? Well, that's why I just asked you. I asked you, does the Consumer Protection, these various divisions, sorry, didn't mean to make, you can follow up in writing, but I just asked you whether these had any kind of time limit on them and whether that's been upheld. Oh, I see what you're saying. You don't think they have. It's never been raised. We don't have an appellate court telling us there's no time limit, but that's your historical position.
That's been our position.
All right,
and I think because each statute raises its own distinct kinds of investigative enforcement issues. And so if there's really a thought, and I don't think there's any history of the Office of the Attorney General over decades bringing stale cases. But if the legislature thought this was a problem that needs to be addressed, then I'll do that within the context of the particular statutes.
And my last question, are there cases that have, we haven't, this is the first time, I think this bill has come before us. I'm not sure about that prior year. So I'm just curious, are there current cases that you all are investigating and are frustrated by because a year has passed? Or is this a systemic problem with
if I may say it in a kind of colloquial way, it's a weird cloud that hangs over almost everything we do. Now, as I've said, it's now very clear in administrative proceedings it doesn't apply. And so that's very helpful. So it's not a dark, ominous cloud, but it's a cloud that we think ought to be clarified.
Thank you.
Yeah.
Thank you. I learned a lot. More to learn.
All right, further questions from the committee?
Thank you, Mr. Chair.
Thank you very much. Mr. Renton.
Thank you, Mr. Chairman, members of the committee, Robert Etton, and I'm appearing today on behalf of the Maryland Bankers Association and the American Property Casualty Insurers Association. And we're very, very much opposed to this legislation. It's been pointed out by questions from the senators. This bill eliminates any statute of limitations whatsoever for causes of action to enforce by the Attorney General. And why do we have statutes of limitations? We have statute of limitations because if you're going to get sued and you're going to be liable for tens of millions of dollars of damages or $5,000 in damages, it's got to be during a period of time when witnesses are available, when evidence is available. We have a 1-year statute of limitations unless you all say for this particular type of cause of action, like and it's in the bill and it's being removed for antitrust, it's 4 years. But instead of coming in with and saying we have this specific problem dealing with cases that we bring in this arena, you have a bill in front of you that completely removes the statute of limitations for every single type of case that the Attorney General can bring for enforcement of any statute in the state of Maryland. And we really find that very, very problematic. When I look at the fiscal note, you know, it kind of stands out to me. And I was trying to I got here a little early, was trying to find the case on the bookshelf up there. It cites this one case, 259 Maryland Act 44. And if that case is what the proponents say it is, then why do we need the bill? But, you know, as this committee knows better than any other committee in the Maryland General Assembly, how sensitive the statute of limitations area is as a matter of law. And in all my years down here, I've seen you change it, you know, dramatically one time. And we all know what that was. And we all know how controversial that was. But it just seems to me it's just patently unfair to now have a sweeping piece of legislation that removes any statute of limitations whatsoever for every single civil action for enforcement brought by the Attorney General. That's why we feel like this is inappropriate, that there's a specific problem that the Attorney General has been unable to address because of this, and that was the question asked by the senator. Fine, bring that in front of you. But this bill goes way, way too far, and we'd urge the committee to give it an unfavorable report. Thank you.
Mr. Wren, not put you on the spot either, but if you or people you represent could also weigh in on the fiscal note and the Attorney General's office saying, look, we believe it's clear that there's no statute in administrative proceedings. So my first question is there a fundamental difference for which that we wouldn't worry about a statute in a civil proceeding, an administrative proceeding versus one in court, or it may be that this has just never been raised and definitively decided by the courts. I don't know, but if you have any information and you would like to get back to us on it, I'm going to read all the information I've been told about. I just found about your testimony.
Well, let me say this. I'd be happy to get back to you. Hey, I want to read the decision. I didn't get a chance to read it, but I would point out that this statute is in the Courts and Judicial Proceedings article. Okay, that's where it is. And so what it says to me is that this is about bringing suits. This is not in the financial services article or in some other the environment article. This is in the Courts and Judicial Proceedings article, and that's the article that regulates what happens in court. And so when I looked at this, what I saw was now all of a sudden for every single action the AG wants to bring to enforce any statute, there will be no statute of limitations.
And actually, the other question I would have to both the opponents and proponents is really what other states do. I don't think we have to follow states. I know that's popular, but I do think it's informative to see what other states have done. And I don't know.
I can reach out.
Are doing in this.
So my one client, the American Property Casualty Insurers Association, is a national trade. And I will ask them that
Yes,
question,
ask
see if
him
they
that
can get us
question
some
from the national
information.
perspective. Thank you.
Further questions from the committee? Mr. Enton, I think we discussed this bill a couple of days ago, or maybe a week ago, and I thought initially the description you gave me was this great expansion of power, or kind of a big policy shift. And so then I went and read the bill, and then the written testimony that was submitted by the Attorney General. And it's the contention that I know this is very clear within the realm of the administrative proceedings, but for civil, that this has been kind of the practice, the accepted norm in practice, but that the specter of this uncertainty in the language in the statute always hangs over the process. And so it doesn't seem to be in practical application that much of a departure from what's actually happening. And so following up on Senator James' question of, has there ever been any sort of motion to dismiss for the statute of limitations within the civil realm? There's got to be like we were talking, some sort of a circuit court, something. There's got to be some sort of a case that kind of, and I would like to see that because that would be helpful for us because it seems like this is not really that much of a departure from accepted practice now.
Yeah. So, Mr. Chairman, the only thing I can say is, the law that they're amending has, I don't know how many years it's been on the books, but it was the policy of the state to have a specific statute. Say, if you want to pass a bill to change the statute, pass a bill to change it for this, for that, or for the other. But if you don't do that, then broadly speaking, the statute is 1 year. I'll be happy to look and see what other states do, see if there are examples. Once again, I didn't get a chance to read the Court of Special Appeals decision. But I'm happy to get back to you all and answer whatever questions I can.
Awesome. Thank you very much. Further questions from the committee? All right.
Thank you.
Thank you all very much. All right. With that, that'll conclude the hearing for Senate Bill 889. Senate Bill 889. We'll now move on to Senator Vice Chair Walzreicher with Senate Bill 899.
Thank you, Mr. Chairman, members of the committee. This bill is quite straightforward. Everyone in the committee has already voted for this bill, and it's in the exact same position it was last year. Earlier this session, we provided address shielding for our judges after an incident in Western Maryland. This bill was designed to stay separate from that because the judges' issues, I think, was pressing timeline wise, but we want to make sure all our constitutional officers are provided that protection, and that's what this bill does. I think the line at the constitutional officers is the appropriate line to draw. They are named in our state constitution, and I would just ask that we keep it at that as we did last year. With that, Mr. Chairman, I'll ask for a favorable report.
Thank you very much.
So I would like to tease out the line. Why not General Assembly members? That's one question. And then the second question is, what makes us as elected officials so special that this should not be a cause of action for all citizens in the state of Maryland?
So I think the quick answer is that executive positions have a higher public profile than any of us. There are fewer of them, and they are specifically laid out in our state constitution. And we know that they receive certain protections that we do not. And this extends those protections to make sure at all times of day they feel safe.
So given that they probably have special protections that most of us don't have, wouldn't that be an argument for the expansion to others outside of these constitutional officers? I mean, none of us here in the General Assembly, once we step out of this room, have a state trooper to look over us. So why not?
So I I don't want to get into the specifics of how executive protection works. But I think it's fair to say that those with existing protections above and beyond what we receive as legislators, that protection can be enhanced. That protection is not absolute. And this builds on the protection that they already have. I think it's an appropriate thing to do. I'm not averse to considering legislators. I'm just averse to doing it in this bill at this time of session. And so if we want to expand upon it, I think we can come back next year and look at how this bill is doing, how the judge's bill is doing, and see if it might be appropriate to move beyond it. For now, I think this is the appropriate line.
And I see Mr. Hicks is sitting next to, is he going to be testifying? Or is he just kind of for information purposes?
Yeah, I did.
Okay, then I'll be quiet.
Come on.
I was gonna say yes, and for the record, my name is Miles Hicks. I serve as Deputy Legislative Officer to Governor Moore, and I'm here today on behalf of the administration in support of Senate Bill 899. When I joined the administration, I learned a lot about public safety, and one of the first topics that actually came across my desk was the actual public safety of the governor and lieutenant governor. And so in that process, we identified some gaps. And when we actually were able to collaborate with the judges last year and the Maryland judiciary last year, we saw opportunity to fill a portion of that gap by allowing the governor and lieutenant governor to shield their home address and personal address, and of course seek damages if people chose not to take that information down. So again, as Senator Wallstreich already mentioned, we did hear this bill last year. This bill is fairly close to the bill that passed last year. We only changed a couple of different words, and we urge a favorable report on this piece of legislation.
And with that said, and I completely heard my colleague about modifications to this law, but I'm wondering, would the administration be adverse to modifications to the law? Again, I have no issue with what is being attempted here. The issue I have is just kind of creating classes of people who have certain causes of actions and others not.
Yeah, we're more than happy to have that conversation. As Senator Wallstreich mentioned, this was the group that we thought, because we've already you have a proof of heightened security risk, that all these people do have, like you mentioned, executive protection to provide support to them. We are open to that conversation, and I'm more than happy to have it with you.
Thank you very much.
Further questions from the committee? All right, seeing none, thank you both very much. With that, that'll conclude the hearing for Senate Bill 899. We'll now move on to Vice Chair Wallstreicher with Senate Bill 898.
Thank you, Mr. Chairman. Very disparate issues between these two bills. If I could grab my panel, Mr. Chairman, members of the committee, before us now is Senate Bill 898. This is actually a really important bill about an issue that I don't think gets a lot of attention. This addresses several provisions in the condo and HOA resale process. First, the bill certifies that what constitutes delivery of required resale packages, which determines when certain cancellation timeframes for buyers go into effect. Second, the bill reduces the timeframes for associations to deliver documents to purchasers and reduces expedited delivery timeframes to reflect that this process is now largely digital. And most importantly, this bill seeks to enforce the maximum fees that may be charged to a buyer for the resale packet to only those that are listed in the statute. Unfortunately, right now, buyers are subject to any number of additional fees beyond what is supposed to be allowed and what we allow currently in statute. The Maryland Realtors are here and can describe further details about this process, and I'm sure they have the technical information if you have any questions to be able to answer that. With that, Mr. Chairman, I really appreciate your listening to Senate Bill 898, and I ask for a favorable report on this legislation.
Thank you, Mr. Chair, Mr. Vice Chair, Lisa May with Maryland Realtors. As the Senator described, many of the provisions that are currently in the Condo and HOA Act date back to a time when those packets were delivered in hard copy, having been over a Xerox machine for hours and then FedExed to the purchaser. Now that is by and large an online process where buyers, but most often their real estate agent, goes online, enters in some information and downloads those packets from a portal. To reflect that this is largely an online process, we have proposed some amendments in terms of what constitutes delivery and tightened up some of those timeframes. And then we also address an issue that is of great concern to our members, which is the proliferation of additional fees on resale packets that are above and beyond what is outlined in statute. And just to give you a sense of what those are, we have heard of portal access fees. We have heard of account setup fees, processing fees. And the one that really got our attention the most was a restocking fee for an electronic document. These particularly for developments where people can be in more than one association, this is several $100s of fees that consumers are paying and that they cannot waive through this resale process. So we believe that the limits in statute should be the limits that are in statute and no more. And so we ask for your favorable report. Thank you.
Thank you, Mr. Chair, members of the committee, Bill Castelli, on behalf of the Realtors. And just a real quick point, you know, when the fees were actually originally put in the statute, at that time, they were pretty generous. You know, it was $250 for a resale packet. There was a built-in cost of living adjustment. So every 2 years they'd be readjusted. So the baseline fee right now is $294. So it was intended to reflect, you know, costs that might increase over time. And so we do think that because it was a generous fee that we put in that statute, you know, 6 or 7 years ago, that we really should lock it down and prohibit these other fees. So for that reason, we'd recommend a favorable report.
All right, questions from the committee? All right, seeing none, thank you both very much. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We have one guest joining us virtually, Mr. Stephen Dunn.
We'd recommend a favorable report.
All right, Mr. Dunn, if you could mute your browser. I know you're probably streaming. If you could mute the browser before you start your testimony, that'd be great to prevent the feedback from coming through. We're ready for your testimony whenever you're ready. Welcome.
Thank you, Mr. Chair, and thank you for having me. My name is Stephen Dunn, and I'm here on behalf of the Maryland Legislative Action Committee for the Community Associations Institute, a trade organization that represents common interest communities and volunteers and professionals who serve them in Maryland and nationwide. I'm here today to voice our opposition to Senate Bill 898 respectfully and request that this committee give it an unfavorable report. As you probably know, the resale certificate is an important part of the home buying process when that home is in a condominium or an HOA. This bill would make the process of requesting and receiving resale certificates much harder. First, it proposes to reduce the time for an association to provide a resale certificate from 20 days down to 10. This is not enough time. Associations have to conduct careful research before providing a resale certificate because they are stuck with the representations they provide. If there was a treehouse in the backyard built in violation of the rules, but the resale certificate doesn't note it, then the association has to live with that violation. The bill doesn't qualify days in terms of business days, so it must mean calendar days. This time period is a bigger problem if the association receives a request before a holiday. Second, it limits expedited service fees, replacing current longer timelines with the ability to impose an $100 service fee if the certificate is provided within 5 days. The probable result of this is that purchasers and sellers won't be able to get resale certificates on an expedited basis. Finally, it changes the timing of when a purchaser must receive the resale certificate from within 20 calendar days of entering into the contract to not later than 15 days before closing. The association is not a party to the contract and did not select the closing date. This change further injects associations into the home buying process and places associations in a position to cause one party to that contract to potentially default. For these reasons and the reasons stated in my written testimony, we respectfully request that this bill receive an unfavorable report.
So thank you very much, Mr. Dunn. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 898. We'll now move on to Senator Reedy. Is Senator Reedy here? I see his chief of staff. All right. Because he has the next two bills, right? The Carroll County. Senator Carter, how many, okay, you're not, okay, good. Senator West, how many witnesses do you have? Let me see. All right, never mind. Here's Senator Reedy right on time. Senator, you're next. You've got Senate Bill 962.
Thank you, Mr. Chairman. I got here as fast as I could. Wonderful, wonderful. Give me just a moment. Mr. Chairman and Vice Chairman and members of the Judicial Proceedings Committee, Senator Justin Reedy here to present Senate Bill 962, which has evolved from our original introduction of the bill into a task force, but a very important task force and one that I think is timely. The bill was originally requested by our local clerk of the court in Carroll County, Heather DeWeese. She had stumbled upon an issue of some pretty severe title fraud in real estate that kind of was a big deal, and she was really concerned about what she felt, and I agree with is a problem in how the law does not completely cover some of these instances of fraud. But as we put in legislation, we discovered that it was going to be overly prescriptive in one area, but not take care of some other issues, and was going to cause some problems and perhaps not actually get to the root of the issue. So I'm just giving that little preface to say, as amended, Senate Bill 962 will create a task force working with the real estate industry and a number of other stakeholders to study the growing problem of property fraud that we've seen throughout the country and increasingly in Maryland. And it's gotten to the point where it's not just unimproved land, which is often the types of fraud we see, where someone has a fraudulent title or deed to unimproved land. Now we've even seen fully developed properties that have become have fallen prey to some of this types of creative fraud. And unfortunately, there's a lot of bad actors out there who have found loopholes in the system and have been able to commit, like I said, title fraud, deed theft, and other types of activities surrounding titling, deeding, and real estate. Deed theft occurs when the title to a home is taken without the homeowner's or the property owner's knowledge or approval. The most common means is through forgery, when a signature on a deed, which is falsified and then filed with a county clerk or registrar. Homeowners also can be duped into signing deeds over to scammers. The original bill as drafted required a seller to provide a title report to a buyer, but after feedback from the industry, and as I said, many different stakeholders, it was felt that we really need more thought to put into exactly what kind of legislative solution we need. But everybody agrees, whether it was the Realtors Association, the Building Industry Association, Maryland Bar, and others, we need to take kind of a deep dive look at this. And we wanted to be able to put it on the books and have it an official task force. And so that's the amendments that you have, is to turn this into a property fraud task force. And with several representatives, with several different entities represented, I will spare you the details of going through each one, but happy to answer questions on this. And I do think it's something we probably need to try to get ahead of as a state, or we may not be ahead of it, we may already be behind. So with that, I'll conclude and ask for a favorable report, and happy to answer any questions.
Did the amendment, would you be able to send that to us? Because I don't.
You should have it. You should have it. It's in
testimony.
testimony.
All right, thank you.
Yep.
All right, thank you very much, Senator. I'll bring up the rest of the panel. I think we have some folks here. So
Oh, I thought this was sponsor. Is the other one sponsor only?
there you go. Yeah, no worries. So Lori Graff, Scott Poyer, is Mr. Enton still here?
I apologize that I didn't call him up when I
Mr.
started
Stella.
talking. I got confused as to which bill was sponsored.
And William O'Connell.
Mr. Chair, members of the committee, Bill Castelli on behalf of Realtors, and we are in support of the bill with the amendments. I'll be very, very quick. This is a very serious problem. The FBI estimates in 2022, $400 million worth of this kind of fraud taking place. People impersonating others, registering title in their name, defrauding someone and basically absconding with their proceeds of sale. So it's a problem and we do need a comprehensive solution and encourage a favorable report.
Thank you, Mr. Chair, Vice Chair, members of the committee, Scott Poyer, Clerk of the Circuit Court for Anne Arundel County, representing the 24 elected clerks in the state of Maryland. We also support this bill as amended, and we ask for a favorable report. Thank you very much. Good afternoon, Mr. Chairman and committee members. My name is Bill O'Connell. I'm the past president of the Maryland Land Title Association. I'm the legislative chairperson of the real property section of the state bar. We support a task force. It's a growing problem day after day. People are impersonating sellers. There's no one quick, easy fix. To the extent that we can get all the stakeholders in the same place to share what they know, what they see, and craft a solution, we're all for that. So we ask you for a favorable as amended. Thank you very much.
Thank you, Mr. Chair. Just a question to satisfy my own curiosity. My understanding is that under current circumstances, the buyer buys the title insurance on the property, and the title insurance is based on the title report, and therefore the buyer is responsible for paying for the title report and the title insurance, not the seller. The bill states the seller should provide that. That's not the way it works, is it?
Correct. It's the bill as it was presented is no longer exists.
Okay.
This is a complete rewrite to come up with a solution. But you're right. I mean, the folks who are doing the settlements, who are issuing commitments and policies, they do their very best to determine that the people who are in front of them are who they say they are, and that they have the ability to sell. And so the industry works very hard to prevent fraud. But you know, the criminals, they only got to get it right once.
Got you. Thank you. Thank you for
Okay.
your answer. Appreciate it.
All right, seeing no further questions from the committee, thank you all very much. With that, that'll conclude the hearing for Senate Bill 962. We'll now move on to Senator Reedy with Senate Bill 1108.
All right. Thank you, Mr. Chairman. Again, members of the committee, for the record, Senator Justin Reedy here to present legislation, Senate Bill 1108, which deals with the oath. It's a local bill presented by the Carroll County Senators dealing with the oath of office. It was actually requested again by our clerk of the court, but it's a local bill. It would make a change to the current oath that's prescribed in Maryland law for deputy sheriffs and deputy clerks in Carroll County. Both the sheriff and clerk of the court support the legislation. It's the oath. We would prefer that our deputies take the oath listed in Maryland Constitutional Article 1, Elected Franchise, Section 9, Universal Citation. That's the oath taken by most elected officials and gubernatorial appointees. It's also administered to deputy sheriffs and deputy clerks in a couple of other Maryland counties, including Montgomery County. So just basically the reason for it is that the current oath that's being given, they don't feel properly aligns with the full responsibilities of the deputy sheriffs and deputy clerks. And so I have some more details on in my testimony, but they would prefer that their deputies be administered an oath which requires deputies to perform all duties diligently and faithfully. And so that's the request in the bill. And it would fall solely on our clerk of court, and there's no cost to it or anything, just trying to make an adjustment to the oath.
You know, Senator, I think I just happened to read the various oaths you could take, and if you don't pull Carol out and put it over there, it's an odd, archaic language if you read the paragraph that I have not heard before. So I think your people probably said that's some odd language. We're not sure what we're doing, and the oath that you're selecting is a much better one, right?
Well, it is, and
It's the one we all are familiar with.
And in all seriousness, we've occasionally had oddities where someone tried to contest that you're sworn properly or in court. And so it just would be better to, and it doesn't usually hold up in court, but it would just be better to it doesn't hold up in court, but it would be better just kind of make it more clear.
Go ahead and read, not now, just later, read
Yeah,
the
yeah.
oath that I think your people have to do right now. I couldn't understand.
It's a bit,
it.
yeah, it's a bit
little
so
weird.
we're just trying to get it fixed. So
Yeah.
thank you.
That's great.
Any other questions?
No. All right. Hey, thank you very much, Senator.
Thank you very much.
All right, with that, that'll conclude the hearing for Senate Bill 1108. We'll now move on to Senator Carter. Ready? No, we go. All right, Senator West, go ahead. We'll go Senator West with Senate Bill 901.
Thank you, Mr. Chair, and it's a pleasure to be here to present Senate Bill 901. This is a rather technical bill brought to me by the real estate section of the State Bar Association. So let me talk about ground rents for a moment. Ground rents were a 19th century way of making it easier for a person to buy residential property. The person could pay a lower price for the home, but then would have to pay a semi-annual ground rent for an indefinite period of time, thus providing the original owner with cash up front as well as semi-annual income for the sale of the property. Today, we finance home purchases through bank loans secured by mortgages and deeds of trust, a far better system than ground rents. But lots of ground rents are still in existence, mostly on row homes in Baltimore City. In recent years, the General Assembly has enacted legislation which has transformed the state's system of ground rents. As a result, Subtitle 7 of Title 8 of the Real Property article requires all ground lease holders to register their ground rents with the State Department of Assessments and Taxation. And Section 8-707 specifically provides that if a ground lease is not registered, the holder of the ground lease may not collect any ground rent payments or bring an action against the leasehold tenant to enforce any rights the ground leaseholder may have under the ground lease. Notwithstanding these recent reforms, there are still some outstanding unregistered ground rents. And in many of these cases, the current leasehold tenant, who is the occupant of the residence, has no idea who is the current owner of the ground rent. So Subtitle 8 of Title 8 of the Real Property article mostly deals with redemptions of ground rents. Over the years, the General Assembly has passed various measures to make it easier for leasehold tenants under the ground rent system to pay off, the word is redeem, their ground rents, and thus get out from under the semi-annual payment obligation. These measures are codified in Title 8. Generally speaking, the redemption system works well. For remaining unregistered ground rents, however, the system is flawed. Senate Bill 901 would make it possible for purchasers of real property subject to an unregistered ground rent to redeem it. Because there's no way to know who owns the ground rent if it's unregistered, the only way for a leasehold tenant to redeem the ground rent in these unregistered cases is through an interaction with SDAT. But under current law, in order to avail himself of the SDAT redemption process, the leasehold tenant must state under oath that the leasehold tenant sent a notice to the ground rent holder. If the leasehold tenant doesn't know who owns the ground rent, then such a notice is not possible. There's another problem with the current statute. It requires the leasehold tenant to affirm that the ground rent hasn't been paid in 3 years, and further requires the leasehold tenant to deposit 3 years worth of unpaid rent with SDAT. So this sets up a mandatory 3-year delay in redemption. And a further problem is that under the ground rent registration system, a holder of an unregistered ground rent is not allowed to collect rent. So the 3 years worth of rent deposited with SDAT can't be paid to the unregistered holder of the ground rent. So how does Senate Bill 901 fix these problems? Very simply, it eliminates the required notice by the leasehold tenant to the holder of an unregistered ground rent and eliminates the required payment of 3 years back rent to SDAT by the leasehold tenant. So I appreciate the committee's consideration of the bill. We'll be happy to answer any questions. And I think Mr. O'Connor is here with us to add further information to the satisfaction of the committee, and then we'll answer questions. Mr. Khan? Did I do it right?
He hit it out of the park. He's the guy, there's nothing really else to say. He explained it perfectly. I'm here to answer any questions that you have. Otherwise, I ask you for a favorable report. The one other thing, well, he did forget to mention one thing. This bill, would like you to conform it to the House bill. There's a couple little minor tweaks that were made in the House, dealing with, the mailing and a redundant, payment of 2 words that don't need to be in there. So if you conform it to HB 1225, we would be much appreciated. And he's already submitted that, I think.
Excellent. Thank you very much. I just wonder how much money SDAT has caught up in this current system. It's really incredible. All right, Senator Sidnor.
Right. The senator gave a pretty legal and technical overview. Can you break it down for me?
Sure.
We have an owner of an unregistered ground lease. This bill is being put in for someone who lives and would like to redeem that ground lease. They can't find the person who owns the ground lease. So what happens?
So, okay, so the way it works is since 2010, all ground rent holders were supposed to register their ground leases with SDAT. If you go on to SDAT's website, you can see, it'll show it if it's registered, it'll give you the name, the address, who to contact. When you want to redeem the ground rent and it's registered, well, you're not going to go through SDAT to do it. All you're going to do is contact the ground lease holder and say, I want to redeem. How much is it? And we do the exchange. It can be done in a week. Through the SDAT process, it takes at least 90 days because they have to post and all these other things. The very reason why you need SDAT in this case is because the ground rent is not registered. If I can't contact the ground rent holder, there's no other way to redeem it. Why this is one of the problems that this creates is that the government sponsored mortgage players, Fannie Mae, Freddie Mac, they require that a ground lease exceed the number of years on the mortgage by at least 5 years. And they don't recognize that these 99-year ground leases are renewable in perpetuity. They need to see that there's, the ground lease was created in, 1960, okay? 99 years hasn't passed, but when they want to make a loan today, it's like, well, there's not 35 years left on that lease. So I can't make a loan to you so you got to go redeem it. Well, if I can't do what's necessary to redeem it, the borrower's in a catch-22. So all we're asking for is to make the law make sense. They've been making change. You guys have been making changes to the ground rent redemption.
Right, but I'm trying to understand the process. I think I had 3 bills from SDAT that dealt with this stuff last year with the 90 days.
Right, that's part of it. This is like the final piece.
So help me out. I want to redeem. I'm on a property with a ground lease, and I don't know who the owner is. What am I the individual? What does this do?
This allows me to file an application with SDAT, pay the redemption amount, and that's all statutory. And SDAT will then post it and they'll wait 90 days.
Okay.
And after 90 days, they will issue a ground rent redemption deed. And they'll give that to the leaseholder. They'll record it, and now they have fee simple.
All right. Now, what happens to that unregistered person, right, and the money that I've now given, what happens next?
So if nobody ever shows up,
Mhm.
SDAT keeps the money.
Or does it go back to the general funds?
I don't know where they take it, but if after so many years, it'll a sheet to the state, I guess.
Gotcha. Okay.
Okay, so but if the ground rent holder does show up, they can
Mhm.
claim it and they get paid just like they would have if they were known at the time of the
That's all,
redemption.
that you just, thank you, appreciate it.
Thank you, Bill.
You're welcome.
I would just say, me too. You covered it greatly.
Okay, great. Thank you very much, Ms. Howard. So with that, that'll conclude the hearing for Senate Bill 901. We'll now move on to Senator West, the Senate Bill 635.
Thank you, Mr. Chairman, and you're gonna have to give me a minute. Somehow my testimony seems to have been hidden away here. Well, I'm not sure what happened to it. All the other testimony was put on top of mine. Maybe we should. This is a little embarrassing. If I could get my computer, I can call it up on my computer and use my computer.
How are you? Oh, Prince George's County. Be on up a white factor.
Okay, let's go to.
How flat.
6:35. There we go. Oh dear, now what happened? Just a minute. Oh yeah, there we go. Okay, I've got it. It's just it's smaller type than I'm used to. All right, thank you very much for humoring me here. It's a pleasure to be here to present Senate Bill 635. Oh, thank you. My aide just gave me the testimony. So, Senate Bill 635 prohibits landlords from reviewing a prospective tenant's criminal history dating back beyond 3 years. The bill also provides that landlords cannot request a third-party vendor to provide criminal history dating back more than 3 years. The bill also states that a landlord may not require a prospective tenant to disclose any criminal history except for information about any requirement that the prospective tenant must register as a sex offender, no matter how long ago such a requirement was imposed. So sex offender registration is an exception to the prohibition on going back more than 3 years, looking at the prospective tenant's criminal history. Along the same lines, Senate Bill 635 prohibits a landlord from publishing oral or written statements that would reasonably discourage a prospective tenant with a criminal history from applying for a lease. And finally, the bill requires the landlord who denies the lease application of a prospective tenant to provide the applicant with documentation explaining why the application was denied. A landlord can legally base denial of a prospective tenant's lease application on one or more of any number of factors. The premise of this bill is while it's reasonable for a landlord to worry that a person recently released from prison might cause trouble in the landlord's rental facility and decline to offer that prospective tenant a lease, after 3 years, the fact that a prospective tenant was incarcerated many years ago should not impede the person's interest in renting a unit in the landlord's property. I appreciate that certain landlord organizations have asked for amendments to this bill. I will be preparing an amendment to the bill that adds to the sex registry exception additional exceptions for convictions for rape and for arson and for malicious burning. Seems to me those make sense. The amendment will add language stating that a landlord that complies with the requirements of this bill may not be held liable in a civil action for failing to review the criminal history of a prospective tenant or for leasing to a tenant with a criminal history. And finally, the amendment will provide that the notification to the prospective tenant of the denial of an application may be transmitted electronically in addition to in writing. So with that, you can expect that amendment to arrive anon. With that testimony, I appreciate the committee's consideration of this bill and will be happy to answer any questions the committee might have. And I've got some good witnesses here who are going to supplement my testimony. Maybe we can let them talk and then we can have all the questions asked at once. Thanks.
Okay, good afternoon. Oh, I want to go up here and do it? Okay, let's go. Good thing I got me after lunch.
Yeah.
Good afternoon, honorable members of the committee. My name is Kiana and I'm honored to speak with you today in support of the Fair Chance Housing Act. As the Executive Director of Life After Release, an organization dedicated to supporting individuals reentering into society based in Prince George's County, Maryland, it is with a heavy heart that I stand here today expressing my concerns and the strike at the very core and challenges that we face as formerly incarcerated individuals with criminal backgrounds seeking stable housing. I speak not only as an advocate, but as a survivor of the injustices perpetuated by the current housing system. Despite my efforts to rebuild my life when I was released and contributing positively to society after my incarceration, I have personally experienced the devastating consequences of housing discrimination based on criminal history. Denied housing opportunities because of my past, I found myself in a desperate situation where I had no choice but to sublease from someone who deeply entrenched in drug use. The decision was made out of necessity and led to an unthinkable scenario where my youngest son was endangered by unnecessary interactions with law enforcement. As a formerly incarcerated woman, this experience brought me severe emotional distress and left me feeling profoundly unsafe in my own home. This harrowing ordeal underscores the urgent need for legislative action to address the systemic barriers faced by individuals with criminal records in accessing safe and stable housing. The Fair Chance in Housing Act, such as the one before you today, represents a beacon of hope for countless individuals like myself who are trapped in the cycle of instability and uncertainty. Further, these experiences not only undermine our sense of dignity and self-worth, but also hinder our ability to fully reintegrate into society as productive can I have maybe 30 more seconds? Self-sufficient members of society. The Fair Chance Housing Act represents a glimmer of hope for individuals like myself who are trapped in this cycle of instability and dehumanization. I urge that this committee support and pass the Fair Chance in Housing Act and take a serious stance for justice. Thank you.
Good afternoon, honorable members, Chair Smith, Vice Chair Wallstriker, and members of the Judicial Proceedings Committee. My name is Rita Gray, and I am honored to speak before you today in support of the Fair Chance Housing Act. As a directly impacted member of the community, I am someone who deeply cares about fairness, justice, and equity. Today, I am speaking from personal experiences as someone who makes enough money to cover their expenses, but faces discrimination when seeking housing. I believe this legislation is a crucial step forward in ensuring that all individuals, regardless of their past mistakes, have access to stable housing and a chance to rebuild their lives. Despite my ability to afford housing, I find myself in a frustrating situation where I'm considered homeless because of the lingering stigma attached to my past involvement with the criminal legal system. This reality is not only dehumanizing, but also deeply unjust. What is the point of working hard and making enough to survive if I'm unable and denied the opportunity to establish a stable home for myself and family? The truth is, the inability to secure housing due to past mistakes reinforces a cycle of inability that makes it very difficult to break free from the shadows of the past. Despite my intentional efforts to move forward and contribute positively to society, I am constantly reminded of the barriers that stand in my way. It is a fundamental injustice that individuals like myself, who have fulfilled our obligations and are striving to rebuild our lives, are still met with discrimination and exclusion in the housing market. Furthermore, this not only undermines our sense of dignity and self-worth,
but also hinders our ability to fully reintegrate into society as productive and self-sufficient members. The Fair Chance Housing Act represents a glimmer of hope for individuals like myself who are trapped in a cycle of instability and dehumanization. By prohibiting housing discrimination based on criminal history and promoting fair evaluation criteria, this legislation offers a glimmer of hope for a brighter future where everyone, regardless of their past, has the opportunity to establish a stable home and rebuild their lives. I urge you to support the Fair Chance Housing Act and take a stand for justice and compassion. Every individual, regardless of their past mistake, deserves a fair chance to rebuild their lives and contribute positively to society. This bill represents a crucial step in the right direction, and we urge you to support this legislation for betterment in our communities and the individuals within them. Thank you for your consideration.
Very much questions from the committee. All right, seeing none. Thank you all very much. Thank you.
Thank you.
I have a slightly longer list, Senator, for testimony. Is anyone else here to testify on behalf of Senate Bill 635? So is that right? So Mr. Castelli? Is that for Shaw? Are you here for 635? Okay. Grayson Wiggins, is Grayson Wiggins here still? Yeah, come on up. It's favorable with amendments. Yeah, come on up. Yeah, I want to say, yeah. Yeah, you can.
I'll go ahead and get started. Thank you, Chairman Smith, Vice Chair Wallstreicher, members of the committee. My name is, for the record, Zuffer Shah from Maryland Legal Aid in our Tenant Rights to Counsel project. And I thank Senator West for bringing this important legislation. We support the policy and co-sign on the statements of these directly impacted individuals that you just heard from. Formerly incarcerated individuals are more likely to become homeless than the general public. They are more likely to be homeless in the period shortly after release. Formerly incarcerated people are twice as likely to be homeless after 2 years from reentry as compared to after 4 years. So the real impact of this legislation would be immediately after return to society from incarceration. And that's why Maryland Legal Aid would seek amendments on this bill to strike the 3-year look back period from the bill. The bill does not provide procedures that are the hallmarks of fair chance and housing legislation around the country, as well as even in Montgomery County. And there's two primary additions that we believe SB 635 would need. One, of course, is an enforcement mechanism. There is none in the current legislation. And we've proposed in the House and here, and I believe this is adopted by the House sponsor, an enforcement mechanism through the Consumer Protection Act. Secondly, the fair chance laws that you often see involve what's called a conditional offer. So if a landlord makes an offer blind to any criminal history, as under this bill, but if they choose to deny housing based on criminal history of some kind, they must have provided the prospective tenant an opportunity to provide any mitigating information as an individualized assessment. So with those changes, we would seek a favorable report with an amendment.
Thank you so much. Whomever would like to go next.
Hello, my name is Tiffany Fisher. I'm here representing the Maryland State Conference NAACP, as well as the Allegheny County NAACP. We are favorable for this bill. I live in a small community that has a lot of prisons in that area, and we see too often that folks come out into reentry and do not have the support that they need to become positive citizens, because it starts where your heart is, which is home. So we are asking that you give them a chance to show that they are rehabilitated, that you support the resources that are available for them to be able to find housing, just like you would support and give resources for them to be able to find jobs and go back to school. Thank you.
Chair, members of the committee, my name is Albert Turner of the Public Justice Center. I am submitting testimony and speaking in favorable with amendments for this bill. While we do appreciate the senator's submission of this bill, we also, in light of what Mr. Shaw said, would like a strike through of the 3-day look back period. In addition, for most jurisdictions that have something very similar to this, there is some type of enforcement language in the bill. The reasoning behind that is, say a landlord does violate this bill, and the tenant would like to take some type of recourse to hold that landlord accountable. They come into a lawyer's office to try to make sure that that landlord is held accountable. Currently, without an enforcement mechanism in the language of the bill, there would be very little to do in regards to a landlord who has offended this bill. We also would like to see some type of definitions in the bill language as well. Criminal history is a very broad language. There is a robust expungement law apparatus in the state, and we would like the bill to kind of reflect that type of robust infrastructure that we had. And for that, we would request a favorable report with the amendments. Thank you. Thank you, Mr. Vice Chair, members of the committee. Ryan Washington with the Apartment Office Building Association. First and foremost, we appreciate the bill sponsor for working with us on favorable amendments. I just want to address a few things that were discussed from the previous speakers on just the enforcement in Montgomery, in Prince George's County and DC. I know in terms of enforcement, they refer to the Office of Human Rights. So we can look into what that may look like on the state level, but they do use those mechanisms. And I believe Montgomery County is similar in that approach. For conditional offer, we have concerns. It's practiced in both Montgomery and Prince George's County. However, the issue with a lot of our members have is it draws out the process for when a new tenant comes in terms of doing multiple background checks for income verification, and background checks can vary from a couple days to a week. And in the event that tenants applications flag for any of these specified crimes, that prolongs their ability to move in the property. So that's kind of one of the few concerns that we have, but we're willing to work with the bill sponsor on some favorable outcomes, and we're appreciative. And I'll stay for any questions. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. Mr. Washington covered a few of my points. My client is interested in looking at this issue and working with the bill sponsor. They would prefer to see a bifurcated approach where we have a 7-year look back for felonies and a 5-year look back for misdemeanors, with certain stipulations on certain crimes maybe being moved around in that bifurcated approach. I would just note that I believe the state has codified a 7-year look back for issues like occupational licensing, as some members of this committee will remember from a few years ago. Additionally, we would like to see the committee look at some liability protections for property owners, specifically at the local level. I'm aware of a situation where a landlord was working with a local jurisdiction, and the local jurisdiction was attempting to remove a rental license for a large apartment community because of, as it was described to me, a dice game happening at the property. And this committee did a couple of years ago pass a law that protected the rental license from non-renewal or repeal for calls to 911. And so we'd like to look at expanding that if the bill is going to move to include potentially criminal activity at the property. Additionally, we'd like to see some liability language protections in the bill if a landlord were to lease to an individual with a criminal history older than is statutorily codified, then there'd be some liability protection. I think that's probably inherent in the law anyway, but just some plain language would be important to my client. And then additionally, as Mr. Washington mentioned, the liability language from DC. And so we have, a long-standing good relationship with the bill sponsor. I've worked on a lot of issues with him and would be happy to continue to have discussions on this bill. Thank you.
Thank you. Before we take additional testimony. Any questions, Senator Sitnoff?
Mr. Wiggins.
I was gonna go sit in the crowd and I was like, that's a bold move in JPR. So I'm gonna stay up here.
The last portion of your testimony where you had mentioned, I guess some sort of limitation of liability. I think I agree with you that it's probably already baked in. So I mean, if the landlord is just complying with the law, then I'm trying to understand how would an argument be made that they should be held liable for, I guess, for not discriminating.
Okay. So and let me clarify, because it's not exactly what I was referencing. I probably wasn't very clear given the 2 minutes. But there were three different liability protections I talked about. The one I think you're referencing, I wasn't attempting to seek liability for how you described it. I was instead thinking of a situation where the landlord leases to a resident. So let's say you put in here that there's a look back limitation of 7 years for certain felonies. The landlord rents to a tenant who had a felony from 10 years ago. And let's say that individual then in some way either damages or harms another resident of the property. We would just want to ensure that there's liability protections in place for the property owner who has abided by the law that's been created by the General Assembly in that situation.
Right. So yeah, we're on the same wavelength.
So I think to your point, I think it is inherent, but I think there's some specific language just codifying that. And I'm aware of a specific case that my client, I can't talk about it. I don't want to talk about it here at the hearing, but I can talk with you about it offline.
So they were following the law and they're being, I guess anybody can be sued for anything.
Yes.
But you follow the law. I can't imagine that you would win the case if you're following the law.
It's an interesting situation. And the current law, the federal look back period is 7 years. And the situation did involve a crime that happened past that. And I don't have clearance to speak about that publicly.
No worries. Thank you.
Thank you, Senator Muse.
Thank you. This is not for you. This is a question from my NAACP cousin back there. Gerald Stansbury, my brother, told me to tell you that you've done a tremendous job with the NAACP in your county. You've done a great job and that you're like our cousin. So I just want everybody to know that's my cousin. Don't mess with her. Bam. Good to see you. Thank you for letting me give me that point of personal.
Of course. Bam, so noted. All right. Is Rita Gray here? Ariana Evans? And then Mr. Pack will come to you if Rita Gray or Ariana Evans are not here. All right, not seeing them. Mr. Pack, you are good to go via Zoom.
Thank you. My name is Gordon Pack. I am a parole advocate and reentry person that works for Prepare. I believe that this particular bill, 635, is great. I applaud the effort, and I really hope that everyone votes favorably for this particular bill. This bill is important because housing is a critical issue for returning citizens. I deal with returning citizens every day. I myself am a returning citizen. I was released under Juvenile Restoration Act a couple of years ago, and I ran into this very problem. After being in a position to save money enough to pay 6 months rent in advance, I was denied an opportunity for a place that I really wanted to go to. And I ran into several renters with the same issue, and you're never told why. You just assume it's because of your criminal record. I believe that renters should have that responsibility of telling you why you're not suitable for this particular housing situation. But I also believe that they're kind of strict. 7 years is a long time. And in 7 years, when someone comes out, that's like 7 years when he won't be able to have that opportunity to find housing. If a person has nowhere to live, that opens the door for a whole barrage of other problems. And what I find with my clients and with my friends, many of them bounce from one residential transition place to another because this is the only way they can find housing until something opens up. So I think it's very important to find renters that are returning citizen freely, but we do need help in this particular area. And I hope that everyone will vote favorably for this particular act. Thank you very much.
Thank you for your testimony. Any questions for our virtual witness? All right, seeing no questions, we'll move on to the unfavorable. Mr. Castelli is here. Thank you, Mr. Castelli.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. And the Realtors represent many property managers. We manage many single-family properties. And we are opposed respectfully to the legislation. We do understand the importance of having a shielding law, and the current law does provide a 7-year shield against any kind of criminal history that you look back. But I do want to make clear that under the current law and under HUD guidance, this is not an automatic bar. And in fact, property managers in our national association and other associations make it clear to property managers that you have to look at the criminal history along with all the other factors that this tenant in terms of their credit and just rental history and other things, so that a criminal conviction is not an automatic bar and should not be used as an automatic bar. HUD guidance clearly lays out that you have to have specific reasoning for looking at that criminal history. You've got to make sure that the nature and severity of an individual's criminal past is weighed, so not all crimes are held the same. And for that reason, we do think the current law works. The 7-year look back gives you perspective on whether there are repetitive violations, and gives you that ability to assess risk. So for those reasons, we are opposed to the bill.
Thank you, Mr. Castelli. Questions for the opposition? All right, seeing no questions for the opposition, that completes the hearing. Thank you to the senator for bringing the bill. We'll now move on to Senate Bill 946, Senator Kelly. And please feel free to bring your panel up.
Excellent. Thank you. And I think one of my panelists is going to be on Zoom, Matt Hill, because he was sick today. So thank you, Sandy, very much for accommodating that. Thank you, Mr. Chairman, members of the committee. I'm here with Senate Bill 946, which was brought to us actually last session by Senator Washington, who's no longer on this committee. So I took it over from him, but you will remember the hearing. I'm hopeful that you will see some changes to the bill this year. Full disclosure, I think there was a robust hearing on this bill last year, and there were some concerns raised by a number of members of the committee, that this might embolden problem tenants at the expense of landlords who are trying to do the right thing. So, I'm cognizant that conversation happened last year, and I just want the committee to understand the frame that I'm thinking about this in, which is that it's not meant to help people who habitually don't pay their rent. It is meant to protect paying tenants who deserve a safe home and deserve not to wake up every day surrounded by rats and mold and roaches and sewage. That's sort of the lens that I'm looking at this through. And I know we all look at these issues through our own personal lens, but and I happen to grow up in a situation that was low income, and I had some personal experience living in places that were really not habitable. So I know that we all look at this through our own lens, and if we happen to be mom and pop landlords and those type of things, our job is to look at this from the different lenses and come up with a work product that I think works for everybody. So I will say that the House cross-file of this bill has been trying to do a lot of work to make that happen. You're still going to see an opposition panel on this bill, I'm sorry to say, but we're getting closer together, I think, in certain issues. So the bill has changed quite a bit since last year. And Delegate Stewart is the House crossfile. He worked over the interim to address a number of concerns that were raised by the Maryland judiciary. They are still not supporting this bill. You will see from the letter, but he is continuing to work diligently with them. He is still working on amendments that I think will be finalized out of the House in the next day or two. Just to walk you through what the bill does, and then I will defer to my panel of experts. The changes from last year include, based on the concerns raised by the judiciary, removing any reference to a collective action or lead plaintiff for rent escrow. That was a large part of the conversation we had last year. Instead, this version of the bill just codifies what is already in practice, that tenants can join together in the same rent escrow case when they meet the current requirements in the court rule on joinder, which is Rule 3-212. It creates a rebuttable presumption that rent escrow should be focused on the tenant paying rent at a reduced amount going forward until repairs are made. This is to increase accessibility for the rent escrow process. And it also separates out the warranty of habitability more from the rent escrow to address concerns that were raised by the judiciary. So those changes were made. That means what the bill currently does is it codifies the status quo in 3 ways, and then it does 2 other things. So the 3 ways that we believe it codifies the status quo in the statute, explicitly listing mold as a reason that renters can file for rent escrow when it's a serious hazard. Adding the implied warranty of habitability into the code, and then clarifying that tenants starting a case for rent escrow can join together under the existing joiner of party rules if a judge decides they meet the criteria of the law. So we believe that's codifying the status quo. The other 2 things that the legislation does, it establish the presumption in rent escrow cases that tenants would pay 50% of their prospective rent into escrow until the case is decided. So in that situation, the status quo right now is 100%, and that really limits access. So we're not, one side of this conversation wants it to be 0, one side of this conversation wants it to be 100. So we're proposing 50. And then the other thing it does is it allows tenants to recover attorney's fees if they win. I know you're going to hear strong opposition on this. Just wanted the committee to know that landlords do already have this protection in their leases to obtain attorney's fees when they enforce the lease. And if a tenant files a frivolous or bad faith complaint, the Maryland rules, Rule 1-341, allow the landlord to recover fees too. So that being said, again, I want you to pay attention to the proponents, understand where this legislation is coming from. We'll hear the opposition panel. Please keep in mind that there are some amendments coming out of the House that we really do hope will mitigate the remaining concerns of the judiciary. I'm going to urge a favorable report and pass it off to my panel. And I think, do we want Matt Hill to go first virtually, or do you want, is that possible? Can we do that?
So I think our tradition is
We
to
can't
say
do that.
virtual.
Okay, we'll do that last.
Yes, thank
So
you.
you'll go first. Thank you.
Again, for the record, Zephyr Shaw, Maryland Legal Aid, and thank you, Chairman Wallstreicher, members of the committee. Thank you, Senator Kelly, for sponsoring this legislation this year. Maryland Legal Aid urges passage of the Tenant Safety Act this year. There were over 65,000 rental units in Maryland in 2021, according to census data, that were severely or moderately inadequate. Last year in Montgomery County and in one single large apartment complex between February and November, there were over 10,000 open code violations at that property. Localities are not equipped. They're not funded adequately to deal with this kind of problem alone. And that's why private enforcement is so important. And the TSA is about that private enforcement mechanism called rent escrow. This bill is about making it accessible, as Senator Kelly said. In terms of accessibility, I want to point you to the multi-plaintiff provision in this bill. As stated, there's no longer a representative action here. This is really about rules of joinder. Last year, Chief Judge Morrissey came to this committee and testified that tenants could bring rent escrows 10 at a time and move to consolidate those cases, and that the court actually would like them to consolidate, in his words, for efficiency purposes. And the TSA is simply moving that type of consolidation, if you will, upstream, so that it's done more efficiently at the filing process and not after many tenants have filed individual lawsuits. So what the court said last year should work this year as a multi-plaintiff joinder mechanism, but the Judicial Conference has continued to oppose the bill. You'll see in their testimony that they still say that individualized determinations are too hard to do. I've on page 7 of my testimony, I've provided you a blast from the past, which is a 1984 case involving 39 tenants filing rent escrow. If it could be done in 1984, it can be done today. We urge your favorable report.
Thank you so much. Whomever would like to go next.
Buenas tardes, mi nombre es María. Buenas tardes, mi nombre es María Enríquez. Soy residente del condado de Montgomery en el distrito 20, miembro de Casa Activo.
I'll be translating. Good afternoon. My name is Maria Enriquez. I am a resident of Montgomery County in District 20, and I am a active CASA member.
Estoy aquí para testificar a favor de la ley. Esta ley no solo trata de justicia en una cuestión de dignidad humana básica, justicia cuando los propietarios no mantienen un ambiente habitable para sus alquilinos.
I am here in support of this bill. This bill is not just a matter of justice, it is a matter of basic human dignity, that when landlords do not maintain a habitable environment for their tenants, they shall be accountable.
En el 2022, nuestra asociación de alquilinos en el complejo de departamentos de Montgomery Guairo ganó una docena de casos a través del depósito de renta, aproximadamente 120 unidades, exactamente los mismos problemas. Sin embargo, solo se escucharon 12 en caso de corte.
In 2022, our tenants association in Montgomery County at the White Oak Apartments complex won over a dozen cases through rent escrow. However, there were approximately 120 units that had these exact same problems. However, only 12 of those cases were heard in court.
Los propietarios son rápidos para demandar cuanto en la renta se retrasa solo un día, refiriéndose a una violación de contrato. Sin embargo, cuando no mantienen condiciones habitables en las que tenemos derechos dicho en nuestros contratos, se demoran y necesitan más tiempo para cobrar la renta igual.
Landlords are sure quick to sue when rent is delayed by even just one day, citing a breach of contract. However, when they do not maintain habitable conditions to which we are entitled under our contracts, they delay and need more time. However, they still charge rent.
En el año pasado estuve si alguno de ustedes o sus familias enfrentan la misma situación, ¿no lo tolerarían? Bueno, estoy aquí para preguntar en lo que permitimos para las familias de clase baja y las comunidades negras, morenas, enfrentamos día a día.
Last year, I was in the House gallery when Delegate Stewart raised a scenario that if any of you and your families were facing the same situations, you would not tolerate it. Well, I am here to ask you the same. Why are we allowing this for working class families and Black and brown communities when they are facing this daily?
Vengo humildemente, les pido que protejan esta ley. Gracias.
I come here to you humbly and I ask you to support this bill. Thank you.
Thank you.
Good afternoon again. Thank you for your time. Again, I am representing the NAACP for Maryland State Conference. This bill is so important because when we look at the demographics of Allegheny County and Baltimore City, where they compare is in housing. We have the moderate quotation mark population that is working and they're at risk of being evicted. So we already have this battle to be able to keep our housing. And now we have the issues with the landlords not paying attention to fixing up the property. The process to go through to be able to complain about what the landlord is doing and putting your funds into escrow is humiliating, frustrating, and doesn't work. This bill allows a space for landlords who are doing what they are supposed to be doing, like our wonderful mom and pop landlord, Senator McKay, to have his process to get people out and fix up his stuff. But it also gives tenants like myself that are dealing with bigger property management companies and other landlords that aren't doing their job a space to stand up for themselves. Every single time I come into this room, everybody talks about statistics and numbers. I just want you to remember that we're talking about actual people. We're talking about the people that work at your Walmart, that work at your local hospital, that take care of your family member in nursing homes. These are the people, and your teachers, these are the people that are renters. And because they do not fall into an income situation where they can get Section 8, and they are also not in a place to purchase a home, we're telling them they don't have the right to have safe, healthy homes and environments. So I ask that you vote favorable in this bill, and the NAACP supports it full-heartedly.
Chair Wildstriker and members of the Judicial Proceedings Committee. My name is Erica Palmisano. I'm a small private landlord, and I speak today in support of Senate Bill 946. If you haven't seen my other appearances before this body, you may wonder why, as a landlord speaking for a bill that makes it easier to have her income temporarily deferred or for a tenant to sue her. It's a running theme in my testimonies. Not all landlords operate the same. I've shared how small and large landlords operate in consistently different ways, but this time we are united facing a different division between landlords who pay to maintain safe buildings and landlords who make money off tenants enduring unsafe housing. Right now, bad actors in our field profit from their inattention or blatant disregard for the law and for tenant safety. Their competitive advantage arises from our legal and moral qualms, and their tenants' functional powerlessness to hold them accountable. Our state should be leading the nation at providing safe and affordable housing, but Maryland ranks 32nd among the states for severe housing problems. That's so many properties with significant issues like high cost burden or insufficient kitchen and plumbing facilities. Building housing takes time and smart policies. Bills before you already address that. Ensuring existing housing is safe, however, is far easier because landlords are already legally obligated to do that. This bill doesn't create an inspection burden. It addresses how tenants hold their landlords accountable. With passage, tenants could easily pursue legal action and remedy in the courts for life-threatening conditions like mold. Groups of tenants could work together when they share a building and a landlord, saving the court's work to address their similar claims at once. Fellow landlords may worry about nuisance suits, but I see a much likelier outcome, a more level field where we're not competing with landlords defying the law and where tenants know they can expect redress from landlords who don't respect their safety. I urge you to give Senate Bill 946 a favorable report, and thank you for your time and your service.
Thank you. Senator Muse, do you have a question? Okay, all right. Any questions for our in-person witnesses? I know we have a virtual witness. Senator Sidner.
Thank you, for Mr. Shaw. And a couple, maybe a few questions. One, can you explain how attorney fees would work in this context?
So this bill does have an attorney's fee provision, which we call a fee shifting provision. Basically, the way that works, I think you see this in a lot of contexts before your committee, a prevailing party would be under this legislation able to seek an award of reasonable attorney's fees and costs. A judge would go through a fee petition and grant under their discretion the amount of fees and costs for that award. The current rent escrow statute does not have any attorney fee provision in it. If you look in, for instance, Virginia, in 2019, they added attorney's fees and costs to their rent escrow statute. Why do we need this? For one thing, and again, I'm as an attorney who oversees our legal aid's access to counsel and eviction program across the state, it's very difficult to be turning away so many renters, low-income renters across the state because our access to counsel and eviction law doesn't cover affirmative rent escrow cases. And at the same time, those folks, whether they're middle income or low income, are not going to be able to attract private counsel to these important cases. And so if you had a group of tenants too who are filing this type of multi-plaintiff case, it's just not likely, although they have a high need for attorney representation, that they'll find that in the private bar. So really the fee shifting mechanism is there, like you have with environmental laws and civil rights laws, to attract that private counsel to do these cases. I think also having an attorney behind the wheel, so to speak, does address concerns that opponents have about nuisance actions or frivolous actions, because attorneys are obligated ethically not to bring that type of case.
And you talked a little bit about rent escrow. I'm curious, can you talk about how rent abatement works or doesn't work with rent escrow?
Yes, so rent abatement should be a very powerful component in making rent escrow a meaningful sanction against substandard housing. So rent abatement already exists under existing rent escrow law. The way it works is that a tenant may seek for a reduction of the amount of rent paid into escrow at the outset of the case. It's actually, according to current law, the landlord's burden to show cause why there shouldn't be an abatement. What we see by and large is that the court will delay any fact finding and ruling on an abatement until after the payment of rent into escrow. I've provided an example in my testimony about a District 43A tenant, one of our clients in Baltimore City, who had already paid several $1,000s out of pocket because of substandard issues in her home that caused her to have to get a hotel. And the judge didn't deny that that had happened. Didn't say that you're not entitled to an abatement either. The judge said, I'll rule on the abatement at the end of the case. And so she had to pay $5,300 into escrow, which she couldn't pay at that time. Her case was dismissed and the conditions of her home were not repaired. So the way it works in this bill is that there is a level setting in this bill, which is called a rebuttable presumption, that 50% of the rent would be abated as 50% of the prospective rent to be paid into escrow at the outset. Of course, the landlord can rebut that presumption, but this is about lifting the target for judges so that they're not putting off the abatement, which is a financial impediment to doing escrow, or providing such a low abatement that the case won't proceed in spite of the court granting that abatement request.
And the last question that I have, and it stems from an issue. I've had a constituent who was emailing my office almost weekly because of a rat issue. But from her emails, it was never a thing that the rats were in her, which I'm assuming the residential dwelling unit. The rats were on the property of the apartment complex. I'm assuming this bill wouldn't address something like that, or would there be a remedy for her that exists under this?
And you mentioned that this is situated on an Army campus?
It's an apartment complex.
Apartment complex,
Right.
I misheard.
Right.
This would benefit that person.
Okay.
If and not just individually, by lowering the financial barriers to escrow and increasing the likelihood of repairs and resolution, but also by allowing that person at the outset of, like, before they even bring their case, to talk to their neighbors who also have that rodent issue and file one action together. And again, that reduces some burdens. It reduces also the likelihood of retaliation. You know, when everyone's bringing one action, they can be targeted. And I'm not saying that landlords across the board do that. Certainly, we do see that, however, that retaliation can happen when bringing these types of cases. It's just less likely when it's many tenants rather than a one-off situation. Thank you for your question.
Thank you.
Thank you. Seeing no further questions for this panel, we'll move on to Mr. Hill virtually. Mr. Hill, you have 2 minutes.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center, which is a part of Renters United Maryland, which is strongly in support of this bill. Right now, Maryland has created a pay-to-play rent escrow process that keeps vulnerable families in dangerous housing conditions and very little incentives for bad apple landlords to make repairs. The rebuttable presumptions and warranty of habitability that Mr. Shaw was just talking about would change those dynamics and help level the playing field. One example from Public Justice Center is our client Carol and her 2 kids who've been struggling financially. Their house was very dangerous. Talking about rodent infestation, Senator Sidner, that's exactly the main problem. The rodents were running through the walls, keeping our clients up at night, and also had a roof leaking in multiple places. The landlord had refused to make the repairs for 3 months, and Carol filed for rent escrow. But at the first hearing, the court refused to even hear her request for a rent reduction and ordered her to pay the past 2 months of rent into escrow to continue the case. While she could pay the rent going forward, she couldn't pay everything the landlord claimed was due and owing. And so the court dismissed her case and left Carol and her kids in a very dangerous house with no remedy. Just to be clear, Carol and the client that Mr. Shaw was talking about are not alone. Baltimore Sun report said the court abates the rent in only 6% of rent escrow cases. And this allows negligent landlords very little incentive to make repairs. And so SB 964 resets the expectation, says if the tenant can prove that the landlord knew and refused to make repairs, then normally, not always, but normally, the court should allow the tenant to pay a reduced rent going forward until those repairs are made. Again, not a mandate, just a presumption that the landlord can rebut. And then with warranty of habitability, that's simply saying it's a defense. It's already implied in the case law. It's just codifying that and saying, hey, you shouldn't have to pay full freight when the landlord's not holding up their end of the deal. We ask for a favorable report. Thank you.
Thank you. Any questions for Mr. Hill? All right, seeing no questions, is Ms. Moore here? Nicole Moore? Tiffany Fisher? Okay, gotcha. Tiffany, you already testified. Nashna Kess? Okay.
She's from the NAACP. She had another bill, so.
Understood. Okay, then we'll move to the opposition. Mr. Castelli, Ryan Washington, Catherine Howard.
Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. Again, the Realtors have many property managers that represent mostly single-family properties. We are opposed to the bill. The one section of the bill that gave us a tremendous amount of concern was the 8212 provision, the warrant of habitability, which seems to be in conflict with the current rent escrow rules. So we think that provision, and we know that the sponsor has spoken about how that an amendment may address that, does create a lot of confusion about exactly what a person would do in terms of what is considered under rent escrow, what are the conditions that would trigger it, and then what that process would be. So we are also concerned about the abatement of rent. A lot of times when a landlord is having trouble keeping up with a property and they don't have the money to make those repairs, not getting that money to help them make repairs makes the condition even worse. So for that reason, we do have some of those concerns. And we are interested in seeing the amendments, but at this time, we are opposed. Thank you.
Thank you, Mr. Vice Chair, members of the committee. For the record, my name is Ryan Washington with the Apartment Office Building Association. We appreciate the bill sponsor for bringing this bill forward, but however, we do respectfully urge unfavorable report on this bill as drafted. We are working on the House side on some favorable amendments. There were a lot of concerns that were raised in our testimony, as well as judiciaries just over on the overall process of it conflating and just drawing out the court process in terms of determination of tenants, especially when they come together in a joinder and identifying the rent escrow and awarding funds. There's a lot of work that needs to be done with this bill, and we look forward to hopefully having some reasonable amendments offered on the House side. And I'll stay for any questions. Thank you.
Good afternoon, Mr. Chair. Catherine Kelly Howard, General Counsel for Regional Management, Inc. One of the first things that I'd like to address in this bill is that the mold hazard portion of the bill seems to be slightly, shall I say, premature. This legislature last year made a task force with regard to mold remediation issues, and that task force has been working diligently. It is due to make a report apparently in the next few months. I don't think that we should be legislating with regard to rent escrow on mold issues and mold remediation issues until after we have some report from that mold task force, because that was part of their the thing that they are supposed to be reporting back to us on. I'm also extremely concerned about the portion of the bill that has the rebuttable presumptions in it, an abatement of rent at 50%. It sounds like a great idea when you hear it from the advocates. However, what exactly is supposed to happen if and when that 50% turns out to be something that should be 100% to the landlord at the end of the case? Clearly it says that that is a possibility, and certainly it is. But I am very concerned that if it is not put into escrow at the time that the issues are coming forth, that the landlord is going to wind up having to go back to failure to pay rent court or some other mechanism to indeed get that rent from the tenant. Those are our concerns, and we appreciate your listening. Thanks.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We're here in opposition to Senate Bill 946. I would echo the comments from my colleagues that came before me. I believe, and I think it's true, that a group of tenants could band together in a joinder action now and pursue a rent escrow, or if you established the implied warranty, I think that could happen now. But the purpose of the Maryland rules on joinder is to simplify and expedite proceedings and to avoid the useless publication, expense, and possible uncertainty of more than one trial. The typical rent escrow case, on the other hand, involves the need to address a particularized problem or set of problems in a specific tenant's unit. In many cases, a rent escrow action can result in multiple hearings, tracking the progress of abatement on a specific issue in a tenant's rental unit. For the vast majority of escrow cases, there will be no commonality between questions of law or fact. An escrow account would still have to be established for each individual plaintiff. A finding of fact would have to occur, and an order of relief would be required based on the specific situation and reasonable rental value of each unit. Even if common questions of fact or law exist between plaintiffs, the highly individualized relief required by the statute would likely subvert the purpose of joinder by prolonging proceedings and increasing the amount of trial and hearing dates until all issues are addressed or corrected for each plaintiff. Let me just also touch on the attorney's fees provision. It's curious to me, in reading the bill, I think it's very clear that the bill speaks to only a tenant prevailing and receiving attorney's fees. I don't know why we wouldn't consider allowing the prevailing party the ability to enter, to have attorney's fees. The other thing that's curious to me is the proponents want only the tenants to recover attorney's fees, yet when we refer back to the governor's renters' rights bill, those filing fees are unrecoverable for us. So the inconsistency is concerning. For those reasons, we respectfully oppose the bill.
Mr. Washington, have you testified?
Yes.
Okay. Senator Charles has a question.
Thank you, Mr. Chair. Now, I know all of the apartment housing units aren't all bad, but I do have some in my district that are horrible, deplorable to be exact. I have folks who are floors about to cave in, people putting complaints about mold, and they come in and paint over the mold. They don't do any type of cleaning of the mold. It's disrespectful to the constituents in my district, what they're going through. Folks are having to leave and go through situations, try to find another place to live, can't get out of the leases. This sounds like it's putting things in place to protect folks and help folks out in the process. Could you explain how someone from my community who's dealing with this right now, they literally have a Facebook group where they post all of this stuff, and I'm constantly having to take my time and coordinate with our DPI office to hold them accountable, trying to make sure
We don't have a press melee going on talking about how horrible these apartment complexes that I have that aren't doing what they're supposed to do. Now, we got great folks that take care of their properties, you know, but I think this is more in line with holding the bad actors accountable. We have to do that. We have to hold the bad folks accountable. The good folks, they're doing what they're supposed to do. They're doing exactly what they're supposed to do, but help me understand that, how I can be a benefit to my community, because this is something I need to vote on to protect my people in my neighborhoods. Tell me why I shouldn't be voting for this, if you can. Thanks.
Yeah, I'll take first stab at that. Yes, and no, I think you bring up some valuable concerns. And I don't think any one of us sitting on this table, support bad actors. I think most of our members that we represent operate in good faith. However, in Prince George's County, I know AOBA, we represent a vast majority of housing in the district. And DPI has a very robust enforcement system where they can revoke rental license for those that do violate or violate, housing codes, life safety codes, in which, those people shouldn't be operating in the county. I think that what this bill does is it further complicates the court process. And our ask is that we come together on amendments to ensure that the court process is not drawn out. It's not expensive for both the tenant or the housing provider, and provide, of course, the needed abatement to whatever occurs. But I think there's a lot more work that needs to be done on this bill, if that answers your question.
Yeah, I know you and I have had discussions about some complexes in my district, some throughout portions of my county in general. I just think we have to have something, and I would truly request that you work with the sponsor of the bill to come up with a reasonable pathway forward that's going to protect everybody at the table, but protecting the people who have to live in those conditions and live in those environments where they don't feel like they have those protections. That's why this bill is in front of us today.
Absolutely. And we could certainly talk offline regarding those communities that are operating, because I have a great relationship with DPI, and, we could figure out what those issues are in terms of those code violations.
I'll let you join their Facebook.
Yeah, I took notes. So
plan to use
I look forward to it.
Good conversation. I appreciate that. Question, Senator Charles. Any further questions for this panel? All right. If not, that concludes the bill hearing for Senate Bill 946. Senator Benson, so glad you're here to join us. We'll move on to your bill, Senate Bill 992.
Did you all put this here in case I decide I want to cry? What is this putting? Oh, thank you very much for that. Good afternoon, Mr. Vice Chair and members of this esteemed committee. And before I speak, I want you all to know we're in the process of voting in my committee. So I'm going to speak and leave the rest to this wonderful representation of some of the finest people that ever walked in a pair of shoes. I really want them to know I deeply appreciate you all being here. And thank you all for that. Thank you so much. Thank you for the opportunity to represent or to present Senate Bill 992. This bill requires landlords to provide a written notice to the tenant 14 days before the scheduled date and time of eviction. After the eviction, the tenant is allowed to recover their personal property that's left on the leased premises for at least 10 days safely and securely. During these 10 days, the landlord may not charge the tenant any fee for storing the tenant's personal property. If the tenant does not reclaim the property within those 10 days, the landlord has the right to dispose of the abandoned property, donate it, or sell the property. However, the landlord cannot dump the property on public streets. Senate Bill 992 offers a win-win situation for the tenant, the landlord, and community. It makes the situation much more predictable. The tenant knows what is happening and can keep their belongings, such as life-saving medicine, electronics, personal treasure photos, mementos, and heirlooms. It is more predictable for the landlord because they know when the law considers the tenant's property is officially abandoned and when they can dispose of that property. It also saves the landlord from having to pay employees to move the tenant's property to the curb. There are also great community benefits with this bill. For example, eliminating putting the tenant's items outside will prevent the clutter and trash on the curb and sidewalk, reduce the encouragement of pests and rodents, and boost the public safety. As it stands right now, Maryland is behind other states when it comes to tenants' rights over the personal belongings. Washington, D.C., New Jersey, West Virginia, Pennsylvania, Delaware, and Virginia all have reclamation periods to allow tenants to access their property. 19 states and the District of Columbia require notice of the scheduled eviction date, provide for the tenant's right to reclaim their belongings, and give the landlord some duty to store the tenant's property. An additional 9 states require notice of the scheduled eviction and a right to reclaim. Even without the notice requirement, 33 states have reclamation periods that are longer than 24 hours. Therefore, I believe the state of Maryland should find Senate Bill 992 essential and must bring Maryland in line with other states. This bill adds predictability around the eviction process, benefits tenants, benefits landlords, and benefits the community, and treats tenants with the dignity and respect that they deserve. Therefore, I am respectfully asking and urging a favorable report for Senate Bill 992. And thank you all so very, very much.
Thank you, Senator Benson. We're going to take the panel before we take questions. We have 31 people signed up to testify for this bill. So we just ask that you keep to the 2-minute protocol and that members try to limit their questions to that which is ultimately necessary.
Okay. Thank you, Mr. Vice Chair and members of the committee. I will rush back. Thank you very much. And thanks again.
Thank you
for
so much.
coming. Appreciate you.
Let's go ahead and take whomever would like to testify next.
Thank you.
Chair, members of the committee, my name is Albert Turner of the Public Justice Center in Renters United Maryland, requesting a favorable report for Senate Bill 992. For many tenants who are looking at an eviction, timing is everything. Can the tenant borrow money from a family member in time to pay and stay? Can they take out a loan? Can they get an advance at work? How long would that take to get the money to stay? When a judgment for a THO or breach of lease is entered, a tenant has to figure out how quickly they can find a truck to move their belongings, how many people they can get to help move them or pay to move. All these questions flow through a tenant's head when they are facing eviction. This cost benefit analysis is made unnecessarily difficult because statewide tenants do not have the right to know when their eviction date is. A tenant who has ample notice of their eviction date can better plan to pay and stay or vacate the premises. Now, even when a tenant has planned to pay and stay or vacate the property in time, we all understand that unplanned events happen. That money you thought you were going to pay by the eviction date fell through. You had an emergency medical bill or child care note you had to pay. You couldn't find a truck or get the amount of help needed to move your belongings before the eviction. And now you are evicted. And in Maryland, when that eviction is executed, not only do you lose the roof over your head, you lose all the personal belongings under that roof as well. The loss of possessions, which may include very expensive items, even cash, can help to further the tenant into financial hardship and may render them chronically homeless. You will hear from the opposition that this law cannot be passed because it is overly burdensome and expensive to landlords, but that does not display as true in other states. As the senator stated, our neighbors, Washington, D.C., New Jersey, West Virginia, Pennsylvania, Delaware, and Virginia, all require the tenant to be given notice of their eviction date and the opportunity to reclaim their personal possessions after their eviction. Overall, 46 states and jurisdictions are currently doing more to protect tenants by requiring notice, the ability of tenants to recover the property or both. These protections are common sense. They have not debilitated the rental market and landlords have not left these states in droves. Thank you very much.
Thank you, Mr. Turner.
All righty. Thank you, Vice Chair and members of the House Environmental and Transportation Committee. My name is Sharnae Hunt. I'm a government worker, a mother, and a renter of the city of Glen Burnie, Maryland. I am here today in support of SB 992, which would protect renters from experiencing the harm that I unfortunately went through. 2 days before Thanksgiving 2022, I was evicted by my landlord while I was at work. That day, I was called by the property manager and told that I owed $300 in back rent and that I needed to pay immediately. Because I was working and did not have time to discuss the matter in full, I paid the $300 over the phone and continued to work. After the phone call with the property manager, I was called by a neighbor about an hour later, letting me know that an eviction had taken place in my building. By the time I came home, I found that all my belongings had been removed from my unit and had been thrown carelessly into the street. It was not long after my landlord confessed to me that the eviction was done in error and that they would be moving my belongings back into my unit. However, the damage had already been done. During the eviction, the landlord's agents damaged, broke, and dirtied my furniture and took my belongings for themselves. I lost precious keepsakes my son had made for me, old passports, social security cards, bank information, laptops, gaming systems, and other technologies. My son's pet turtle was also sent away that we were never actually able to recover. Because of the traumatic experience, I moved out of the unit and in with my parents while me and my son tried to make ourselves whole again. If SB 992 was a law, this experience would have never happened to me or any other Maryland tenant. The law would make sure that evictions, whether done in error or by law, tenants would have the right to access their personal and sacred belongings. I ask for a favorable report on SB 992.
Hello, my name is Sai Suma. I am a IT student, YO program graduate, and qualified handgun instructor for the state of Maryland. And after 3 months of homelessness and a bunch of accomplishments between, I rented my first apartment. In December 2023, I was evicted from my home and subsequently lost a number of my personal belongings. And on the day of my eviction, I had been aware that I had owed money and sent my landlord the rent payment by Western Union in a full amount. However, I only had the receipt and the landlord didn't have the receipt. So I was subsequently evicted. I support this bill because it would allow me to vacate my property or vacate my items from the property with dignity. I was out of my house when the first notice of eviction was sent through certified mail, as the notice was returned to the office, and during a 7-day period, both notices were posted on my door, even the mail in the envelope. I was able to get a U-Haul on the day of my eviction, but due to the holiday scheduling, it was very hard, but I toughed through it. I was fortunate enough to get a truck. I was promised 7 days to recover my items, but on the seventh day, I was locked out. Me being able to see the little bit of items that I had left that were incredibly valuable from the window of the property. I lost instructors' manuals, tools, I lost business calendars, items that were essential to my employment. And I lost my diploma, my certifications gained from my entry and graduation from my YOGA program. And it was devastating for somebody who had worked so hard and had been out on his own since the age of 16. Maryland renters and foremost, emerging youth that need stability and education deserve a reclamation period after the eviction occurs to mitigate the financial and personal loss that evictions cause. Had this bill been law, I would have been able to experience something that Marylanders do not get to experience now at this moment. And I urge you for a favorable report on this bill.
Thank you so much. Whomever would like to go next?
Hello again. Thank you again for the opportunity to speak on behalf of renters in Mountain Maryland and rural areas. I am Tiffany Fisher from the NAACP, representing Maryland State Conference and Allegheny County NAACP. The opportunity to be able to walk through a process that is already traumatic as eviction and have dignity when you leave is so important. Typically, folks are not evicted because they chose not to pay the rent. They're evicted because circumstances did not allow them to pay the rent. So putting the added pressure and funds of having to find transportation and storage for your belongings is huge. It also gives space for the resources that Senator McKay spoke of the other day that we have within the community to be able to support those renters in need, such as social services, local church groups, organizations like the NAACP and their housing committees, and other avenues. This window keeps homes and families together. It's not just about an item, your clothes, your sofa. It's about finding a place to call home. If we do not have our communities living in housing that is safe and protected and they feel secure, it's a trickle-down effect of how they perform at work, at school, and in community. It also helps with the rural areas in our communities who do not have homeless shelters. In Allegheny County, we only have the Union Rescue Mission and some places that you go if there's a family crisis, but that family crisis does not include an eviction. So I ask that you please vote favorably and for this bill. I ask that you consider the human beings that are attached to evictions and not just the funds that the landlords aren't receiving. Thank you.
Good afternoon, Chair Wallstreicher, members of the committee. My name is Lisa Sorrow, and I am General Counsel with ACDS, Anne Arundel County's Housing and Community Development Agency. We administer the county's eviction prevention program and coordinate the county's continuum of care agencies and the local coalition to end homelessness. Evictions overwhelmingly affect households with children present. In fact, the average evicted household includes at least one child, and the most common age to experience an eviction is during the critical formative years of life. That is to say, babies and toddlers from birth to age 4 make up the largest age group of evicted persons in our country. I provided a link to an important new study by Princeton and the Census Bureau in my testimony, and I would urge you to take a look. When a family is evicted and they lose everything, the family's crisis becomes a crisis for the entire social services, school, and homeless prevention community. One of our county agencies recently assisted a grandmother who has custody of her young grandson. They were evicted and lost everything, including vital medication, the grandma's walker, all the legal custody documents, and all of the grandson's belongings, including his cherished mementos of his deceased mother. Another family they served is a single mom with mental health challenges with a disabled son who uses a wheelchair. They lost all of mom's mental health medication, a multitude of medications for the son with cerebral palsy, a breathing apparatus, diapers, along with the rest of their belongings. Now, in addition to the many barriers barriers to finding affordable housing. These families need for daily life. They need housing and everything. They have to replace it all. We urge you to consider that counties need to take care of those most in need, and this bill will help us to do that. We urge a favorable report. Thank you.
I think everyone from this panel has testified. Is there any questions for this panel? If not, we'll move on to further witnesses. Jordan Colquitt, Destiny West, Julie Hammer, Catherine Davis, Erica Palmisano.
Good afternoon, Mr. Vice Chair and members of the Judicial Proceedings Committee. For the record, my name is Jordan Colquitt and I'm representing Community Legal Services of Prince George's County. I've worked at CLS since 2018 and currently work in our eviction prevention department, which provides free representation to low-income tenants throughout Prince George's and Anne Arundel County. I'm here to voice our full support of Senate Bill 992, the Tenant Possessions Recovery Act. CLS supports this legislation because it addresses important issues regarding dignity of individuals and families, environmental concerns, and the modernization of state practices. Maryland renters deserve advance notice of eviction dates, allowing them to exercise their statutory right of redemption to pay to stay or to make necessary arrangements for relocation. Dealing with the already drastic predicament of an eviction, the least that we can offer Maryland tenants is an opportunity to reclaim their treasured items. Without a reclamation period in place, this is sadly not the reality that many renters and our clients who face an eviction experience. In many areas across our state, tenants' personal belongings are carelessly thrown into the streets after an eviction, resulting in clutter that creates environmental and safety concerns. Senate Bill 992 is a pragmatic step forward, aligning Maryland with our neighbors on eviction practices. Washington, D.C., Virginia, Delaware, New Jersey, Pennsylvania, and West Virginia all require that tenants are provided notice of their eviction date and a reclamation period. This is a common sense bill that provides long overdue protections to Maryland renters. Community Legal Services urges a favorable report on Senate Bill 992, the Tenant Possessions Recovery Act. Thank you.
Good afternoon, Chair Wallstreicher and members of the committee. My name is Catherine Davis. I'm the Director of Pro Bono Resource Center Maryland's Courtroom Advocacy Project. We support Senate Bill 992 as a common sense way to make evictions work better for everyone. Last year, we represented over 2,400 tenants in Baltimore City and Baltimore County in eviction-related matters and spoke to over 1,000 on our hotline, many of whom were calling to ask what to expect after receiving a judgment, specifically how to find an eviction date. We tell Baltimore City callers to look out for a notice in the mail and on their door. For callers in other jurisdictions, it gets more complicated. We tell them to call the constable's office, who will then, based on their address, connect them to a specific constable who handles their area. They may have to leave a message and hope for a call back. We advise them to keep calling every few days. We also suggest they just call their landlord. One client sticks out in my memory. She was a 75-year-old woman and had gotten a judgment and was working with United Way to secure rental assistance. One of our staff attorneys was actually on the phone with her when she heard the banging at the door. Our client was surprised and unprepared. She had some cash on hand, but not enough to stay the eviction. Our attorney listened as she raced up and down the stairs in her townhome, first looking for a wallet and then for her inhaler as she became increasingly short of breath. All renters deserve reliable notice of their eviction date so they don't have to scramble. Equally important is the reclamation period so they can retrieve property. We've had tenants call to ask about retrieving passports, birth certificates, refrigerated insulin, and Chromebooks for their children's school. But it doesn't have to be this way. The point of an eviction is the transfer of property back into the hands of owners, not the destruction or loss of the personal property of the tenants. Senate Bill 992 provides common sense solutions that will benefit everyone, and we urge a favorable report. Thank you.
Chair, Vice Chair, and members of the Judicial Proceedings Committee. I'm still Erica Palmisano, and I am a private landlord speaking today in support of Senate Bill 992. I became a landlord out of familial necessity. My partner's work took us out of state for 3 years, and selling our home made no fiscal sense. We became temporary landlords. When we returned in the fall of 2020, we allowed our tenants to remain, finding ourselves alternate housing. I took over management to save money, and temporary became permanent. Perhaps that's why I relate more to tenants facing eviction than large landlords do. Those who take on multiple, even many properties must struggle relating to each human being they shelter. Certainly, their double to triple eviction filing rates suggest a disconnection from the reality on the ground for renters. The reality can be a lawn outside a door once considered home, littered with clothing, papers, household cleaners, photos, medications, and that bag with returns waiting for errand day. A tenant has no warning and may discover it hours later. They start closer to scratch, without shelter, and with fewer necessities for daily living and mementos from which to draw strength. Even 2 years later, they're likely to struggle with health, employment, access to credit, and securing housing. I've dealt with an eviction. Government policies form incentives that help landlords make decisions about them. But the guardrails on eviction notices and tenant possession recovery are not strong. Expensive ethical consideration can give way to thriftier cynicism, assuming we have no responsibility since a contract ended badly. Is that what we want to incentivize? Corrosive apathy and social disengagement in this economy? Fellow landlords may disagree. They may claim this puts too great a burden on us. I believe just as we ask tenants to treat our property with care, we should treat theirs with the same, even when evictions are necessary. I urge you to give Senate Bill 992 a favorable report, and thank you for your time and your service.
Good afternoon, esteemed members of the Judicial Proceedings Committee. I'm Destiny Drake West, a Democratic congressional candidate for Maryland's 6th District and former program lead for the U.S. Department of Housing and Urban Development's Federal Surplus Property Program, which is a program established to combat homelessness across the nation. While much of my recent work has focused on tackling affordable housing issues at the federal level, today I'd like to bring that discussion back home to amplify the ways in which SB 992 would benefit families in District 6, which covers Up County, Montgomery, Frederick, Washington, Allegheny, and Garrett counties. As you know, federal funding that once provided a temporary reprieve during the eviction moratorium has been discontinued. Yet, in the face of inflation, 33% of our families are still struggling to meet their basic needs. I'm talking food, transportation, healthcare, and yes, housing. Even under normal circumstances, eviction takes a devastating toll on families, extending far beyond the loss of shelter. We're talking increased rates of mortality, substance abuse, suicide, low birth weight, and a wide range of physical and mental health issues. SB 992 is not just about legal procedure, it's about mitigating the human suffering that eviction inflicts. This bill provides vital notice to tenants, allowing them to stabilize, seek help, and explore alternatives, while also minimizing burdens on vulnerable families in our community through clear procedures and fair property disposition post-eviction. How we treat the most vulnerable among us is a direct reflection of our character and values as a society. And so for these reasons, I urge that you provide a favorable report on this bill. Thank you.
All right, excellent. Thank you all very much. Questions from the committee? Seeing none, thank you. Is Edward Blackstone here? Ashley Esposito. Come on up, ma'am. Come on up, sir. Demel Ross. Demisha Rucker. Okay, excellent. Whoever would like to start, you can come up to the podium and get us started.
Okay. Donnie, Ryan, John. They're my cousins from Baltimore. Good job today.
Okay. Thank you, Chairman and members of the committee. My name is Ashley Esposito, and I'm the Executive Director of Baltimore Renters United that supports tenants across Baltimore City. We are here to support SB 992 to allow tenants to require a landlord to provide enough notice for tenants during eviction. I'm here to share stories collected by our tenant organizer and Rent Court Watch lead, Indigo Null. We do not know a single tenant who has been evicted who has not lost possessions. We had a tenant who was evicted several weeks ago whose father passed away. She lost everything, and she managed to recover her father's wedding ring because her landlord told her what shop he pawned it at. Another tenant lost her birth certificate, ID, passport in her eviction and was thus unable to be hired at her new job because she literally had no forms of identification proving who she was. We know multiple tenants who now sleep with their doors locked with chairs under their handles because they were awoken by landlords and sheriff deputies bursting into their rooms unannounced. One tenant still sleeps fully clothed with shoes next to her bed a year later because of this experience. We've seen children lose their school books, their clothes, their favorite toys. Community members walk past scenes where tenants are publicly shamed with their remaining belongings sprawled along the sidewalk, like the scene I saw this morning on my way down Monroe Street in Baltimore City. Why are we able to give tenants enough or landlords advance notice, but not tenants? Do tenants lose their right to their personal property just because they are facing hardships and unable to pay their rent? A tenant who doesn't know their eviction date can't arrange movers, pack their things, or find their essentials. Evictions are already traumatic enough without a tenant losing irreplaceable items. Tenants deserve the right to plan and keep what's left of their lives together. I urge a favorable report on the TPRA. Tenants deserve some level of predictability in a time that is already so chaotic and traumatic. Baltimore Renters United requests a favorable opinion with no weakening amendments. Thank you.
Thank you, Chair, and this committee. My name is Danisha Rucker. I am an equal justice works attorney at Homeless Persons Representation Project. At HPRP, I am a homeless youth advocate. HPRP urges this committee to issue a favorable report for Senate Bill 0992. I am here specifically to uplift the story of one of my clients. My client name is Tamika Brown. Tamika Brown was evicted last year and was not, although she was aware of the eviction, from her understanding the eviction was paid, but she did not have proof of that. She was evicted with her 5 children. All of her items were strewn apart and thrown out in the alleyway behind her home. This is a picture of her entire family's belongings in about a 10-feet alleyway. Not only that, the landlord was able to get rid of valuable possessions that included the ashes of her son, and as well as dispose of them in her face. Not only that, the landlord was able to come to this eviction execution date with a dumpster truck, and she watched as they put her items in a dumpster. This specific bill would have protected my client with not only allowing her to understand her rights through the notification requirement, but also have an understanding that the eviction was going through, and also give her a grace period to reclaim her possessions that can never be replaced. We ask at HPRP that this committee issues a favorable report for Senate Bill 992. Thank you.
Hello, everybody. My name is Edward Blackstone. I am the Youth Collaboration Coordinator at Homeless Persons Representation Project, where I work with homeless youth and young adults not only learn how to advocate for themselves, but also reclaim their lives. And I'm also a former Baltimore City educator for 7 years. So I just want to start with my own personal experience. So when I was 15 years old, I came home from school one day and I was unable to have access to my belongings. And one thing that I did not realize is that when I walked away, I had no access to any of my vital documents. I was unable to gain access to youth works jobs. Even when I graduated, I was unable to apply on my FAFSA because I did not have these belongings. My sister, who was also with me, she was unable to have access to birth control. She dropped out of high school, so she was unable to do reentry programs to get her GED nor certification classes. During my 7 years as a Baltimore City educator, I worked with elementary, middle, and high school students who would come to school distraught because they had gone through many of the same things that I had gone through, which lets me know that this is generational. This is not something that just affects us, this affects our future as well. I want to be very candid with what I'm about to say next. Is the simple fact that when you're born in this country, you're given a document that certifies you as a human being. Over your lifetime, this is used concurrently with other forms of identification, and so such as your social security card. When you're in elementary, middle, and high school, you get forms of ID. When you go to college, you get an ID, you get a driver's license, state ID. And over this time, you also gain items that you use to feel like you've enhanced that feeling of humanity. So this could be when you graduate from elementary school, honor roll records, et cetera, et cetera. I just want to say that, apologize. I just want to say that when you lose these things, I realize that you lose an aspect of your humanity, and I vote to support Senate Bill 992 because when people have gone through significant traumatic experiences such as homelessness like I did, I had full understanding that I was going to be homeless after that experience, but I did not realize that when I lost access to my belongings, I would lose an aspect of my humanity as well. Thank you.
Hello, everyone. My name is Levi Johnson. I'm the co-chair of the Baltimore City Youth Action Board. The Youth Action Board is a youth-led organization consisting of youth with lived experience of homelessness. We work to create and execute solutions for youth homelessness, as well as ensuring preventative measures and are implemented within legislation. The board and I agree that Senate Bill 992 will be very helpful in ensuring that during the eviction process, youth are not penalized for things that they never had control over in the first place. To lose access to your property as a youth, we have found that this makes the rehousing process nearly impossible. Oftentimes, we find youth in the need of basic necessities and they are unable to get them because they cannot access their property. This also raised another concern by young people. A lot of youth potentially are being at risk of getting their identity stolen, and having your social security card, birth certificate, passport, and IDs into the wrong hands will make an unfortunate situation. The Baltimore City Youth Action Board requests a favorable report for Senate Bill 992. Thank you for your time and consideration.
We've got one more person joining us virtually, and then we'll open it up for questions. She's not there anymore? Okay. All right, questions from the committee. Senator Muse.
Just to say very quickly, thank you all for your testimony. As you all know, this is important to me, the person who lived on the streets, slept on the streets, went through hell, and finally having a roof over my head at age 13 was the biggest thing that ever happened in my life that changed it for the better. So I commend you on what you're doing, and we're here to help you. And I believe that the answer to the question is, isn't that right? Yes. Okay, they agree. They agree. Thank you.
To echo the sentiments of the senator, thank you all very much for your testimony. Thank you. Excellent. All right, so that it looks like that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel. Mr. Castelli, Mr. Wiggins, Mr. Washington, and Ms. Howard.
Yes, yes. Yes.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors. As I've stated before, our property managers represent mostly kind of single family homeowners who rent out their properties. We are respectfully opposed to this bill. There are a number of provisions that I just wanted to point out in terms of some of the provisions included in the bill. One, it does add a provision that would add another 10 days where you would essentially keep the tenant's property as they've discussed in the property itself. I will tell you that from the current process that we go under, a lot of landlords go under right now. It is months, oftentimes when you get a court date. And when you get to court, and then it could potentially be another month before the sheriff is able to go out to the property and execute the warrant. So there is a lot of time that is built in, a lot of time that a tenant has to get their property. And I will tell you, in the single family case, a lot of times what happens is that a tenant will, in fact, vast majority of times, the tenant will take out all of the property that they want and leave behind personal property that they don't want. That includes sometimes furniture, it includes sometimes clothing. So a landlord would be put in the position of having to just keep that property there because the tenant's not going to come back to claim it. They don't want it. And then that is another expense, another delay in terms of getting that property back online. And I think the system is set up because we do want to return rental property back to the market as soon as possible so that other tenants can get that property. So for that reason, we do recommend it.
Good afternoon. Thank you, Mr. Chair, members of the committee. For the record, Ryan Washington with the Apartment Office Building Association. This is a very, emotional and traumatic issue with evictions, and we are sympathetic to those tenants that have been traumatized by this. However, I'd just like to quote, with Montgomery County, they have a really robust system of providing. The sheriff's office provides 2-week notice for evictions. I think that onerous of providing that notice should be on the sheriffs if that is what needs to be done for ample notice. Additionally, during an eviction, a landlord has to require the ledger before they move forward with the eviction. I've witnessed evictions where a sheriff won't evict someone if they don't have that ledger, which stipulates the information of the tenant, the unit, and that such, and the amount that they owe rent. And just following up with Mr. Castelli's points, I think that, it adds a lot of cost in terms of the storage of the actual property. Evictions is a drawn out process in Montgomery County and Prince George's County. It takes about 4 to 6 months, 146 on a good day. And with that, that's revenue of rent that's collected. And then of course, turnover costs, renovations, redoing the flooring. And now you're asking housing providers to hold someone's a personal property for 10 additional days. I think that's just economically infeasible for a lot of folks, especially our members that already have a drawn out court process on top of rent stabilization in some of these jurisdictions where they cannot increase rent for a certain amount. So we respectfully urge unfavorable report on this bill. Thank you.
Good afternoon, Mr. Chair. Kathy Howard for Regional Management, Inc. We are here today to let you know that in Baltimore City, there is a 7-day and 14-day notice that is already in Baltimore City Code. What you don't know and what hasn't been discussed here today is an ongoing lawsuit that is now is on appeal at the Fourth Circuit Court of Appeals in the Todman versus the Mayor and City Council of Baltimore. There is a case, the case really turns around on whether or not that kind of notice should be used, not just in a failure to pay rent case, which we all agree should be done, but rather it is supposed to be, is also allegedly in that case being, the question is whether or not a tenant holdover and a breach of lease case deserves that kind of scrutiny, because they are two different types of possessory actions for the landlord. I know that this sounds very complicated, but basically the appellate argument is not due to be done until the 22nd of this month. And I think it will definitely affect whatever has been already done in Baltimore City, Prince George's County and other municipalities that do have these reclamation periods and also the notice periods. And I think that it would be premature for this body to act on this until after the Fourth Circuit appellate arguments and the opinion is drafted and sent out. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I'll be brief. Proponents covered a lot, or excuse me, the previous speakers have covered a lot of my points. I just want to note that, so in Baltimore City, for example, I believe there are already 6 points of notice in the rent court process. This would be creating 2 points of notice. There was discussion of notice in the bill. There's actually 2 notices in the bill. This would be get us to at least, I believe, 8 points of notice. And I think, you know, my understanding in Baltimore City is that they don't have a reclamation period, and that policy was put in place in large part because organizations that just testified supported it. And I think to their point that they've made today and in the House hearing is if the notice, the point of the notice is to prepare the resident for the eviction so they can become, you know, ready to move, then why is the reclamation period necessary? They seem to be attempting to cover the same goal. I would also note that the bill does not allow for the property owner to in any way charge a resident for the during the time of the reclamation period, meaning, as Mr. Caselli mentioned, the property is staying in the unit at I guess just free of charge. Additionally, you know, we talk a lot about the need for more affordable housing in the state. I think that reclamation period and really codifying 24 days into the eviction process is going to keep more units off the market for longer. This also doesn't just apply to failure to pay rent cases. This applies to breach of lease and tenant holding over. So if a resident, the lease is ended, resident refuses to leave, refuses to vacate the property, landlord goes through the entire process, eviction occurs, they now have to let the tenant back in who previously wouldn't leave after the lease had ended. And finally, I would just know that the bill requires the landlord to allow the property or make the property reasonably available during the reclamation period. That's not defined in the bill. And one last point, Mr. Chair, the bill does have a private right of action, which wasn't really discussed very much by the proponents on page 11. And ironically, they're clear that court costs can be recovered. And given their testimony on some other legislation in this committee, that's a very ironic position to take. Thank you. I should have been more brief. I apologize, Senator Fold. I apologize.
Thank you very much for your testimony. Questions from the committee? All right, seeing none, thank you all very much. Thanks. All right, with that will conclude the hearing for Senate Bill 992. We'll now move on Senator Folden with Senate Bill 885.
Chairman, esteemed colleagues of the Judicial Proceedings Committee, for the record, Senator William Fulton, representing Legislative District 4 in Frederick County. So before you today is Senate Bill 885, and this is just an amendment to already legislation that's already in place regarding the termination of rent of leases and liability for rent due to medical conditions. Basically, what this does is, prior to this, a patient was required to be moved to a home facility or an institution to be able to break a lease for medical conditions. This language would allow someone that experiences a medical condition to be able to, with the obvious, still consistent with the current law, a notification from the medical provider that the person is unable to continue to care for themselves at this point, and that they should be moved to from a medical professional or a professional caregiver, or even be moved back to a family member's residence. This basically comes about as a result of Blake Mason, who was a college student, recently diagnosed with an illness, tried to go off to college. When he was off to college, parents assisted with paying the lease. After the first semester, the young man is unable to continually monitor his proper blood sugar levels and was causing great issues for him attending classes, missing classes because he was unable to control his diabetes, and he was falling asleep and had fatigue issues and still learning to navigate the disease. Once contact was made to the leasing office was like, yep, we understand. There's already we'll help you get a sublease over the winter break. You don't have to worry about it. Comes back to the end of the winter break and they're like, yep, sorry, we didn't get anybody. So you still got to pay the rest of your remaining lease at that point, which was 7 additional months at $1,400 a month. So and then their reasoning was that they did not have to, because under the current law, it's only if they're moved to a medical facility or a home or institution. So there are other medical conditions that require constant monitoring and can have an effect on our people, our citizens, and we should be doing things to help them. Obviously, there's still a penalty associated with it to help facilitate them to a better, healthier life without penalizing them for the additional 7 months at $1,400 a month. So with that, I would ask for your favorable report and field any questions on Senate Bill 885. I like it. I'm with you. We're there. There you go. That's it. We're there, buddy. Historic.
It's too much love in this room right now.
It's because it's the last bill.
Second to last bill.
And we have a wonderful dinner this evening, so.
Oh, man. Together.
Thank you, Mr. Chairman.
All right, thanks. All right. Thanks a lot, Senator Folden. That'll conclude the hearing for Senate Bill 885. We'll now move on to Senator Carter, Senate Bill 1031.
Good afternoon, members of the committee and Mr. Chairman. I'm so happy that so many of you are still here. This is not a very long day, and so maybe we're not too tired to give our full attention to this very, very important bill. I will tell you that all of my bills are important to me, but this bill touches my soul in a way that most don't. This bill is about lead poison, and it's about how we have never done right by the victims of lead poison in the state of Maryland. I'm certain that we all can agree that no child's potential should be limited by a preventable toxin such as lead. As you know, last year we passed the child sex predator bill, which we should have. We finally gave adequate consideration to those victims, those persons who were abused as children by persons in position of authority, which was a preventable thing. But we recognize that sometimes their harm and their memories were such that they weren't able to discover and remember what had happened to them until many years later. As horrible as those victims' circumstances and trauma is, it is possible. They all have a possibility of recovery. But there is one group of people, one class of victims that have suffered greatly at the hands of those who have benefited by causing them harm, and with the complicity, many times, of this legislative body, and they have suffered from the scourge and the ravages of lead poison. It is a miracle that many of them have survived at all, stymied as they have been, by the blocked roads to economic justice and compensation, political apathy, and at times even cruelty. In 1994, this body, before many of us, not one of us was here, I think, back when this terrible bill was passed. But in 1994, I don't know, Senator Muse, you might have been in the House side, I'm not sure. In 1994, this body passed a horrible bill that they claimed was a bill to benefit victims of lead poison. It was the Lead Poison Recovery Act, they called it. 1994, they finally took a step, but the step was so horrible, it was actually literally written by the Property Owners Association lobby. In 2011, our Supreme Court, the Court of Appeals of Maryland, in the Dackman case, struck down that law that this body passed. And the Supreme Court quoted that not only is the law unconstitutional, but the paltry amount that this legislative body afforded the compensation for victims of lead poison amounts to no recovery at all. No recovery at all? Wow. Over the years, there have been efforts to impose greater fines and penalties on massive lead violators and repeat offenders and slumlords and property owners that repeatedly violated the lead laws. And those bills have all died, not just by me, but by many people over many years. Never, ever passed one of those bills. There have been multiple bills since way before my time and all during my time for market share liability to hold the paint companies accountable for their role in this known toxin. The paint companies knew it was toxic. They sold it and distributed it anyway. The property owners knew that their places were contaminated with lead. They rented them anyway. And so, members, we have a moral obligation to safeguard the health and well-being of all of our citizens, but especially the most vulnerable from a known danger, and we have failed to do so. I believe that going forward, not only should we pass this bill because on principle it is the right thing to do, but in addition to that, because I noticed there is an opposition from the insurance companies, really. So I don't know why they're opposing it, because they were able to get away with excluding lead hazards from coverage. So I don't even know how they're even impacted by this anymore. But they still, yet they have the unmitigated gall to oppose the bill. So with that, I've talked a lot about why we have to pass the bill and how we failed our people by not doing so. So I'll just briefly summarize what the bill actually does. It ends the statute of limitations on recovery for lead victims. It also removes caps for non-economic damages. There are some people in this committee that think that's a good idea. Well, there would be no group of people that should deserve it more than these victims of lead poison. It does provide for affirmative defenses, and what else? And it also prohibits a state or local government or a county school board from raising a defense of sovereign immunity for claims brought under the bill that exceed specific claim limits. As I just said, it establishes an affirmative defense if the owner or manager of the property complied with specified environmental laws at the time the plaintiff was exposed to lead-based paint hazards on the property. The bill's provisions are severable, and the bill must be construed to revive an action barred by the statute of limitations applicable before October 1, 2024. So many of our bills deal with public safety. So many members of this body all want the same thing, but have very different ways of getting at the public safety, the safety of our constituents. One of the biggest contributors to the lack of public safety, to criminal behavior, to filling our prisons in Maryland with a higher percentage of Black people than any other state in the country, well, that's because of lead poisoning in large part. If you test it today, the people that are in prisons, an overwhelming majority of them would have been impacted by lead poison as children. That's already been determined, and there is no doubt in my mind that that is true. One of the reasons why I said this is so important to me is because when I was a new lawyer, I spent a very little bit of time working as a SINA lawyer at Legal Aid, and it was the late 90s, and when I went into the SINA unit and all the lawyers were telling me about, all the things that our children were infected with. Every single child in the 1990s, every single child that was a SINA child, every single one had lead high lead levels. And I'm like, lead? Thought that was taken care of when I was a kid. I had no idea of the prevalence of it and how it continued to go by through government corruption and complicity and just go unabated for such a long time. I promise to wrap this up shortly, but I hope this body will do something about this. Whether it's this bill, which we should pass, because I think that equal protection under the law of equity, the sheer law of equity would mandate that we would ensure that people that are permanently damaged and destroyed, potential completely eliminated, eviscerated, would at least have the same option for recovery as persons that are fully capable of recovery. And so with that, I'll end my testimony with a challenge to this body to do better by these children and these victims. It is not okay what we have done up until this date. And whether you believe in a statute of limitations or no statute of limitations, I actually don't believe in it. I believe there should be limitations on all actions. But now we've said that for one group of people, we won't have it. And I'm saying if there's any group of people that it's warranted, it is this group of people. Thank you very much. And that ends my testimony for today on this bill.
Thank you very much, Senator. Senator West.
Thank you, Mr. Chair. Two things. First of all, I don't see any members of the plaintiff's trial bar prepared to testify. I'm a little
There's a
surprised.
written testimony from MAJ.
Is there? Okay, I haven't seen it. I'll have to take a look at it.
Well, one of the reasons they don't have that many cases anymore is because of the exclusion in the property association. It's simply not lucrative to do these cases anymore. And that's even if we don't pass this bill, we need to do something about that. That this body needs to do something about those property insurance exclusions that cause no recovery as well.
But the second, with the passion that you bring to this, which is genuine, obviously genuine and strong, I sort of feel like we're hearing about lead paint for the first time, but it seems to me Peter Angelis, for example, has made his fortune litigating asbestos and lead paint cases all these years, and the fortune is considerable, and it enabled him to buy the Baltimore Orioles. So we're not at the beginning of this. We probably could have come to this General Assembly 30 years ago and heard similar impassioned testimony. And there have been cases all along. So why is it so important now, 30 years down the road, to eliminate the statute of limitations? I would have thought that argument would have been a stronger one 30 years ago.
I think that, so my answer to you is, first of all, there's been, as I spoke about, there's been a multitude of attempts to get justice in this area. We refuse to pass high fines and penalties for the violators and the culprits. We refuse to pass market share liability. I think the efforts were in those bills over the years by many, many people, but repeatedly those bills never passed. So now here we are. We couldn't get the market share liability, which we should have. We couldn't get, the fines, high fines for the worst offending slumlords. So my thought is, all of these adults that are walking around having had their lives completely destroyed because of that brain damage caused by the lead ought to have an opportunity to get a real recovery. And so that's the reason that I'm bringing the bill, not because of I did speak about this last year when in all the years that we were entertaining the sexual predator bill, that we shouldn't only do it for that one group. We should do it for those that are permanently destroyed as well. So, I think there will be, as you said, Senator West, there's going to be a floodgates, a plethora of bills, get rid of the statute of limitations. Heck, we just had one this year for something else. For a criminal thing. We've done it in the criminal arena a lot more than we've done it in civil. But in this instance, I just believe that these victims deserve justice. And on principle, we need to do something to reverse the harm that this body has caused.
I just wanted to respond that last year there was the expectation expressed by some that last year's House Bill 1 would be one-off, eliminating the statute of limitations. I was not of that view. I thought that it was going to generate lots more bills, and we now have 2 today. And as you say, we're probably going to get a lot more in the future. We started down this road, and I think we ought to stop going down this road. You're not going to agree, isn't that so?
No, I don't think so. I don't think we should do it for everybody, but I do think that when people are permanently harmed, their entire potential in life stamped out through no fault of their own by someone that financially benefited from causing them the harm, we need to really look at extending that statute of limitations so that they aren't barred from recovery beyond a 3-year period, which most of them have a limit on right now.
All right, thank you very much, Senator. Seeing no further questions, thank you, Senator Carter.
Thank you, and that's a wrap, right, Mr. Chair?
We've got a couple folks here testifying in support of your bill, and then we've got one person.
That's right. I didn't know they were still here. I would have
Ms.
brought them
Kess is here,
up.
and Ms. Amador, yeah, you're up here. Yeah, welcome. And then we've got Mr. Washington, who will testify in opposition.
Hello, good afternoon. Nashana Kess, the Executive Director of the Maryland NAACP. And thank you for hearing us for the members of the committee. Lead poisoning is not merely a public health issue, it is a social justice issue. For decades, Black families in Maryland have borne the brunt of the devastating consequences of lead exposure, primarily due to the prevalence of lead-based paint in older housing stock found in our urban areas. The impact of lead poisoning in Black communities cannot be overstated. It robs our children of their futures, impeding their cognitive development and perpetuating cycles of poverty and inequality. The consequences of lead poisoning extend far beyond physical health. They seep into every aspect of a child's life, hindering their academic achievement, perpetuating behavioral issues, and ultimately limiting their opportunities for success. Furthermore, by eliminating limitations on damaging awards to prevailing plaintiffs, this bill ensures that victims of lead poisoning and their families are not further marginalized by arbitrary legal constraints. It acknowledges the long-term cost of lead poisoning, both in terms of medical expenses and the profound, often lifelong impact it has on individuals and communities. Let us be clear, this bill is not just about compensation, it is about justice. It is about acknowledging the systemic failures that have allowed lead poisoning to ravage our communities for far too long and take decisive action to right these wrongs. Let us remember that the fight against lead poisoning is a fight for racial justice. It is a fight for fundamental rights of every child to grow up in a safe and healthy environment. I urge the committee for a favorable report. Thank you.
Good afternoon, Chair Smith and members of the committee. My name is Ninfa Amador Hernandez, Policy Analyst with CASA, and I am here in favor of SB 1031. SB 1031 addresses the serious health consequences of lead poisoning and ensures fair compensations for victims of lead poisoning. The overwhelming majority of CASA's more than 155,000 members are working class and immigrant individuals and renters of color who live in older, dilapidated road housing or apartment complexes at an enormous risk of lead poisoning. Renters should not have to decide between safe housing or affordable housing. However, many Marylanders already encounter significant obstacles in their struggle for fair, safe, and fair housing and affordable housing. CASA's housing team works closely with these individuals who are facing uninhabitable living conditions in bringing cases against their unresponsive landlords. However, from language barriers to time constraints, many CASA members do not have the necessary resources it takes to gather the sufficient evidence to hold their negligent property managers accountable in a timely manner. Lead poisoning has severe health consequences, ranging from developmental delays to even death. Current law puts renters on a timer. However, in communities lacking easily accessible healthcare systems, identifying the underlying cause of a condition, such as lead poisoning, can be delayed. This issue is particularly prominent in our communities of color. A 2022 survey of Maryland residents found that 22% of respondents of color said that they went without care due to costs. Most Maryland renters are also families of color. They already grapple with escalating rent and eviction risk and even must endure health and safety hazards due to property neglect. Eliminating the statute of limitations on lead poisoning claims enables affected families, often unfamiliar with the legal process, or who who are delayed in receiving health diagnosis, to hold accountable property managers who are putting the health and safety of tenants at risk. CASA respectfully urges as a favorable report. Thank you.
Thank you both very much. Questions from the committee? All right, seeing none, thank you all very much. Mr. Washington.
Yes, thank you, Mr. Chair. I know you all had a long day, so I'll be brief. You all have my written comments. My name is Ryan Washington with the Apartment Office Building Association. I appreciate the senator's passion and vigor on this bill. We do have some concerns on just rescinding that statute of limitations, as lead is a naturally occurring element on this planet, and there could be other factors that produce it. In the study that I quoted in my testimony in 2006, there was a study conducted on some of HUD's properties, and they came to the conclusion that the lead dust that was found on some of the door and window sills was in fact coming from exterior sources from outside. I think the concern comes in that, you know, this bill would place a significant amount of responsibility and onerous on the housing provider for lead, which is already heavily regulated on the federal and state levels to ensure compliance. So we request a unfavorable report, and we can certainly share our concerns further with the sponsor and look for something to address this issue of, you know, lead being a case of folks, you know, having high blood levels, but this bill has a lot of issues that we raise in our testimony and others have. So I'll remain for any questions. Thank you.
Excellent. Thank you very much, Mr. Washington. Questions from the committee? All right, seeing none, thank you very much. With that, that'll conclude the hearing for Senate Bill 1031 and our hearings for the afternoon. Have a good evening.